everyone. Welcome to Crime in Court. My name is Heather, and this is the 1996 Menendez brothers trial. Eric and Lyle Menendez on trial for the homicides of their parents, Kitty and Jose. And so this is now their second trial. They had a trial in 1993, which ended in a mistrial. This is now their second trial, which they end up in a conviction. So we are reading through the transcript because unfortunately, Judge Weisberg, in his infinite wisdom, decided not to allow cameras in the courtroom. So all we have is a transcript. So unfortunately, you have to hear my voice, and that's not great for everybody. But you know what? It just is what it is. So let's get started here. I wanted to show you or remind you really quickly of what we have on the Google Drive. So there is a link to this Google Doc. You can also find the trial transcripts and you can go in and look at them. So we've completed October 11th. That was day one. That was opening statements for the prosecution and opening statements for Eric. We are now going to be doing the opening statements. This is October 2nd or 12th, which we are moving on to, which is the opening statements for Lyle. So if you recall, in the last trial, the 1993 trial, there were two sets of juries, two sets of attorneys. In this trial, it's a little bit different. It's going to be one jury and still two sets of attorneys. So let's kind of go over that real quick here. This is the Google document that I created. I'm going to be updating it as we go along. I'm just going to make it a little bit bigger here so you can see. So we have the 1996 Menendez brothers witness testimony. I'm going to be going through and updating witnesses week by week as we go along. So you'll have them. This is the attorneys on record. So for the people of California, it's Gil Garcetti is the DA. Then we have Carol Nahara. Then we have David Kahn. For Lyle Menendez, we have Michael Judge, Charles Gessler. He's going to be doing the opening statement for Lyle. And then we have Terry Towery. And for Eric Menendez, we have Leslie Abramson. Again, she returns to represent him. She's the only one returning, her and Stanley Weisberg, the judge, who they both butted heads a lot in the first trial, if you recall. So I'm sure we're going to get a little bit of that too in this trial. We also have Barry Levin for Eric Menendez. Like I said, the same judge is back presiding again over this case. And this trial took place from October 11th, 1995 through April 1996. So let's get started. Let me I can get rid of that. So we're going to go over to the October 12th testimony. This is the transcript, and it's we'll get through all of Lyle's opening, but we'll start a little bit of Leslie Zoeller, the lead detective of the case. He is going to be the first person on the stand. We'll get a little bit of his, and then um, I'll break it up because he's on the stand for a while, so we'll keep going with him. All right, so let us get started. This is October 12th, 1995. The court says in the trial, the defendants are in court with their lawyers. The people are present. In any matters to discuss that counsel wanted to discuss before we have the jury out, Mr. Gessler for Lyle says, "Yes, Your Honor, I presume that after my opening statement, Detective Zoeller, I believe, is going to be their first witness, and we've just been given this morning a new transcript of the interviews with Lyle Menendez and Eric Menendez." So they're in the middle of trial. This stuff happens quite frequently, and it has to be infuriating. So they're getting an updated new version of a transcript of interviews between Detective Zoeller and Eric and Lyle Menendez. On the day of trial, the day it begins, with lead detective Zoeller coming up on the stand. This is some kind of bamboozle tactic to really, I mean, don't you feel ambushed? I would. It's a total ambush from the prosecution. So they're up to dirty tricks, we see. Moving on. Originally, I was told of Lyle the one of Lyle had been redacted and I'd have to check it. In other words, with the one that was used last time to see why. Now, Carol tells me that this is, and Judge Weisberg interjects and says it's not Carol, it's Miss Nahara. Mr. Gessler says, I'm sorry. Yes, Miss Nahara tells me but this is the same as before. I don't know about the Eric one. However, Eric Menendez's transcript as to what new or different redactions have been made on that. Since we have the one jury, I need to know that. Also, because there might be something there might be something there in the new version that is prejudicial to Lyle. Ms. Aronson says, Yes, Your Honor. Our concern is that since the people announced several weeks ago that they were not going to try to prove up in any way or use the Calabasas burglaries, it's our position that the transcript of and the tape of the September 17th, 1989 conversation between our client and Detective Zoeller should be redacted to remove reference to it. It's in there on page 31 and on. And in the last trial, the court may recall the court had ruled because these tapes were played that the burglary information could come in because Dr. Oziel was testifying. And in this case, this trial, it isn't coming in. The court says, let's stop. Are these going to be played this morning? And Mr. Khan says, yes. Ms. Abramson says, that's what they tell us. And we raised the issue with them, and they've just given us the new transcripts. And they first told us that the Eric Menendez tape had been redacted anew to remove the Calabasas reference. And then Ms. Nahara said, that isn't true. And it isn't true. I see it. And they also said that the Lyle Menendez transcript had been redacted in some unspecified way, and apparently that information has now been given that it was conflicting. But the fact is, we don't have time to read these right now, and I believe that with respect to the Eric Menendez one, it certainly does have to be redacted, so we'll need some time the court says, okay, what is the people's response? He just cut her off. He does that so often. I really cannot stand this judge. So Ms. Nahara says, Your Honor, for the record, on the Eric Menendez tape, I believe that we had a discussion in court and the court ordered some specific redactions, specifically what the court ordered the people to do with regard to changes from the tape and transcript on the first page was to take out the last line on page 33 and all of page 34. Those were the court-ordered redactions, and we have complied with that order. So right now, the transcript that we have prepared and the tape that we have prepared comply with all the redactions that the court has ordered the people to make from the first trial. The issue that counsel is raising as to Eric Menendez was never ordered. As to Joseph Lyle Menendez, Your Honor, the transcript that we have given to counsel is the same transcript that was the exhibit that the same transcript that was the exhibit in the first trial, so it has not been changed except for any redactions that were made as a result of the first trial, and that also complies with what the court ordered us to do. The court, Judge Weisberg says, all right, as far as the Lyle Menendez tape recording, Mr. Gessler, if that is the situation, then there's nothing further to do. Mr. Gessler says, no, there's no problem. It was corrected just before the court took the bench that this was a mistake. Okay, so the court says, okay, so we're set with that one. As far as the Eric Menendez tape, I don't recall the defense making any objections or requests for redactions regarding the burglary. Miss Abramson says, I don't know that they were specifically made, Your Honor, but the fact is that it's obvious if the people aren't going to go forward with other crime evidence, that it's just pro forma that you don't refer to the other crimes. I mean, I'm sorry if it was necessary to bring it up specifically, but nevertheless, this tape now contains a reference to that. And I have the testimony of Detective Zoeller. He understood when these words were spoken to him that it was a reference to the Calabasas burglaries. Ms. Nahara says, Your Honor, if I may respond briefly, the transcript, I think that the reason it was not mentioned before is because the transcript does not mention burglaries. It mentions basically one. The words are basically made us get one after the Calabasas thing. That's the only reference to anything in the Calabasas thing. There is no reference to burglary. And the people would not try to elicit any information that this was related to a burglary. And the court has actually read the transcript before, and I think the court determined all of this at our previous hearing, and that is why it wasn't ordered redacted. The court says this particular issue was never raised to my recollection. I do recall the reference, and it doesn't refer to burglary, and there's no way a juror would conclude it is a reference to some other criminal act. Ms. Abramson says, well, but when it's preceded by my parents basically made us get one in reference to the word psychiatrist after the Calabasas thing, I mean, the inference is wrongdoing of some kind. Usually parents don't make kids get psychiatrists unless they've done something wrong. The court says, well, is there some dispute that it's going to come out in the defense that the parents could cause your client to go to a psychiatrist or a psychologist? And Ms. Abramson says, we have not made a determination that that's going to be a part of our case. The court says, it seems to me that somehow, some way, the relationship of your client with Oziel is going to be developed. If not during your direct examination, then during cross-examination. Ms. Abramson says, we haven't. That is an issue that is yet to be litigated, Your Honor, and we intend to bring an in limine motion on that issue, which in the context to which the people can try to elicit information about the relationship with Oziel when they have chosen not to call him, and the scope of any cross-examination they may do on Eric Menendez about Dr. Oziel or anything said to Dr. Oziel when they have chosen not to put a confession on in their case in chief. The court says, well, it depends on what is mentioned during direct examination. You've already referred to what you expect your client to say in his examination. You refer to that in your opening statement, which, depending on how it is brought up in direct examination, opens the area up for further inquiry. Abramson says, well, my client certainly, he interrupts her again. At this point, she says, at this point, he says, I'm dealing just with this issue. She says, right. The court says, and if this is the reference that you object to, I find that it's totally innocuous. It doesn't direct the jury's attention to any criminal activity or misbehavior or by either defendant. Mr. Gessler says, Your Honor, I have an objection on behalf of Mr. Joseph Lyle Menendez to that same sentence because it says my parents basically made us get one after the Calabasas thing. Us, obviously meaning himself and his brother. The court says, all right. Mr. Gessler says, I think that's an Aranda issue. I don't know what that is. Not just the 352 issue as to whether it can be inferred as being a burglary, but it also implicates Lyle. The court says it doesn't implicate him in any criminal activity or any crime, it just refers to his brother. Mr. Gessler says implicates him as needing a psychiatrist, and that can have a large variety of meanings to the jury. The court says, okay, was this objected to by you in earlier proceedings? Mr. Gessler says no. The court asks why in earlier proceedings, Your Honor, but I am now, as I see the final redacted version given here. The court says, okay, I'm faced with Mr. Gessler, interrupts the judge. I again thought that all references to Calabasas, meaning the incident and burglaries, would be deleted since it was not coming out in trial. But I didn't make the specific objection because I didn't think the sentence would be in here. The court says, okay, several observations at this point. This is an exhibit that the people proposed to use today, and from what I understand, the people provided it to the defense today. Now, it seems to me if this trial is going to proceed in the way that I envision it, and I tell you it will, any exhibits that either side intends to use must be furnished to the other side at least 24 hours before they are to be used to that so that we don't have this last minute nitpicking over exhibits when the jury is in the jury room. I mean, that's a great idea, but it doesn't always work out that way. You're also ordered to be here at 8:30 so that if there are any objections and issues that have to be addressed, you will bring them to my attention at 8:30, not at 9 once the jury is sitting in the room. A lot of attor- um, a lot of judges can get really irritated when lawyers make the jury wait. So that can be a sticking issue here. So, as I view it, the people are at fault for not having the exhibit ready and presented to the defense in time. Heck yeah. The defense is at fault for not objecting to the things months ago when these issues were originally litigated. Aw. So it's a loss for both sides. This tape recording was the subject of litigation prior to the ruling on whether there will be one or two trials in this case, and the specifics of the two tapes were referred to, and objections were made, and the court made rulings a long time ago. And it's the defense is at fault for not addressing this issue long before now. Of course, he says it's the defense. Of course. This judge I just cannot stand. Mr. Gessler says, Your Honor, I don't think the people had made up their mind about whether or not they were going to use the burglary evidence. I think it was more recently than that we talked about it in court. But the primary problem is even being here at 8:30, which we were, we got this exhibit approximately 5 after 9. Miss Abramson says, we asked for it. Mr. Gessler says, immediately before we called it to the clerk's attention that we need to talk to the judge before the judge comes out. The court says, where in the tape of Eric Menendez is this? What page? Ms. Abramson says 31, Your Honor, page 31, 2 pages from the end. Okay, and we have other testimony before we get there. We have all the Lyle Menendez tape and other events that lead up to that. Is that correct? Before we ever get there. It might not even be this morning, depending on how things proceed. All right, we'll deal with it further at a recess, and you can provide me with the same exhibits that you folks have been referring to, so I have some idea is, so what it is specifically that you're talking about. Ms. Towery says, Your Honor, when you say that we are to provide the opposing side 24 hours before we intend to introduce them, that doesn't include exhibits to be used for impeachment, I assume. Is that correct? The court says, well, the rules relating to discovery have been set forth in the discovery order, and those rules are to be complied with. If you are holding back on a particular exhibit for impeachment purposes and it doesn't fall within the discovery order, then you need not disclose it before it is used or before it is to be used. You still have to show it to the counsel before it is actually used. But if you want to avoid delays and want to avoid what could very well occur by an interruption in cross-examination by the court directing you to move on to some other issue so the opposing side can digest what it is you propose to use, you're better off disclosing it ahead of time. But because I don't envision a lot of these delays that will interrupt the proceedings, you'll just have to be flexible enough to move on to other questioning in other areas so we don't have delays while the opposition reviews an exhibit that hasn't been disclosed at the time. Damn, he's just like, I don't care if you don't like it. We're going to move on. All right. Are we ready to proceed now? Miss Abramson says, can I ask one question on another subject briefly? Yesterday, the court indicated you wanted us to give you a list with time estimates for our witnesses. Are we going to be bound by those time estimates? Because if so, we're going to err on the side of caution and estimate a little bit more. The court says, well, you gave the court the length of time estimate before the trial started, and in your opening statement, you referred to the defense taking 3 or 4 months, which would go beyond the time estimate that was given to the court before the trial started. Ms. Abramson says, well, that's just to make sure that that is the way we sort of fib to juries so they don't get. The court says, I don't fib to juries and I don't intend to have the defense take 3 or 4 months. And I expect you to be realistic in your time estimates as to how long each witness will take. This guy is kind of a jerk to Ms. Abramson already starting off. I mean, we're on day 2. She says, we will be, but my question is, yesterday, for example, I underestimated the time of my opening statement, and obviously the court was relying on the time estimate. And I just want to know if these estimates for witnesses is something the court's really going to rely on and prohibit us from going beyond. I mean, I really want to know if we're going to wind up with fixed time allotments for witnesses or if this is the court asking this so the court has some sense of how long the trial is going to take. The court says, I want a realistic sense, not some sense of how long each witness will take. Obviously, I can't bind you to a precise minute count of how long a particular witness is expected to take before it's developed during examination. But I expect counsel to be realistic and not just arbitrarily add 50% or 100% to the time estimate of each witness just so that you are not caught in a situation of having underestimated. But I think you should be realistic, both in direct and cross examination, based upon what you know of these witnesses and what they have to say. And you're aware during the first trial when counsel gave me time estimates of how long a hearing would take, how long testimony of a witness would take, or various time estimates, and I told the jury those time estimates and those estimates proved to be wrong. I told the jury that the folks gave me those estimates and you were wrong. That you folks gave me the estimates that you were wrong, and I will not be reluctant to do that in this trial. Wow. He's basically telling Leslie, cut your stuff down. Be more concise. Don't go overtime. Like he only has to cut like he only has problems with her, issues with her. She did have a lot of people on the stand for quite a long time, but she takes a long time to like develop a story as she questions people on the stand, and I think she does an excellent job of it. But Judge Weisberg, because he doesn't like this whole thing and he thinks these criminals are, or he thinks the brothers are criminals, and he really doesn't give them much of a chance. So there's that. He's very biased. All right, Ms. Abramson says, it's very hard, frankly, Your Honor, to estimate time. I mean, I know you like to have a feeling, and so would we, but I don't have any special skill in doing it. I can tell you who is a 10-minute witness, but whether someone is going to be 3 hours or 5 hours, the court says you're professionals and you've tried many cases and you have a good idea how long witnesses will take. Mr. Gessler says, what's particularly difficult, Your Honor, if we're to form how long our opponents will take in cross-examination, if I can bind them by putting 10 minutes down, that's okay. I don't know what he said there. The court says what can happen is that each side will provide a time estimate and the other side then propose or suggest how long their cross examination will take of the same witness so that both sides can then combine and give me a realistic estimate as to how long each witness will take. All right, let's get the jury out, please. Ms. Abramson says, Your Honor, we don't have to list our clients on there since the decision is always ours to make until the end. Court says, I thought you had already made yours. She says, Is that a question? He says, No, it's a statement. And then the jury enters the courtroom. Court says, Good morning, welcome back. We are ready to resume with the trial. The jury is in the box, and as we left off yesterday afternoon, counsel for Lyle Menendez indicated that you had an opening statement. Mr. Gessler comes forward. He says, Thank you, Your Honor. Mr. Gessler continues with an opening statement. Good morning. You've heard from two lawyers already and the judge what an opening statement consists of. Obviously, as everybody has said, it's not evidence. It is, again, a guideline a guideline to you as to some of the evidence that we expect you will learn in the case or hear in the case. And again, a reminder that the evidence really is what comes from the witnesses, not from the lawyers. But that is not confined to the side that calls a witness. In other words, evidence is evidence and the witness is a witness. I mean, what kind of, that's how you start out? In other words, evidence is evidence and witness is a witness. Okay. And evidence that comes out on cross-examination from a prosecution witness or by the prosecution from a defense witness is as much evidence as anything else that the witness said when put up on the stand by the side that called the witness. So the important thing is that cross-examination by either side is just as important as a direct examination in bringing out evidence, and no side owns a witness. Detective Zoeller, I anticipate, will be presenting evidence and he will be called by the prosecution. And yet, anything that Detective Zoeller says, whether asked by Mr. Kahn, Ms. Abramson, by the defense for Lyle Menendez, is equally valuable as evidence to be considered by you for proof. So anything that happens in this trial, you can consider, even if it's for Eric. Well, because it's the same jury, so they can consider it all. So the only which is different than last time, because obviously they would have kicked Eric's jury out, and it would have just been Lyle's jury in the room while these were being presented. So the only exception to that is when the judge gives a limiting instruction to you saying that certain evidence is limited for either a certain purpose or to be one client or to another client. And that I will give an opening statement. With that, I will give an opening statement on behalf of Joseph Lyle Menendez as to some of the things that I anticipate that the evidence in this case will show. Lyle Menendez was the oldest son of Joseph. No, his name wasn't Joseph, was it? It was actually Jose, I thought. All right, anyways, he was treated as the oldest son with the high expectations that Jose Menendez had for him to carry on the family name, and it is best described in a passage that Jose Menendez had Lyle Menendez memorize. And Lyle Menendez had other friends of his memorized as to a credo in life. It is from the author named O.G. Mandingo, and it quotes, I am not a sheep waiting to be prodded by my shepherd. I am a lion, and I refuse to walk or talk or sleep with the sheep, for their disease is contagious. I was not brought into the world for failure, nor does failure course through within my veins. This is the credo by which Jose Menendez brought up his eldest son, Lyle. He was to be a lion. He was not to be a sheep. Failure was not to be tolerated. Winning was everything. And with this credo, Jose Menendez received from his son love. He commanded respect and he engendered fear. All of these things, and you will hear evidence as to how each of these played a part in the family. For example, of carrying out this credo that Jose wanted and was as he saw it, success for his son, you will hear evidence from a witness, an adult at the time, a family member who saw an occasion in which Lyle Menendez was 5 years of age and he was running off some nervous energy. He didn't stop the minute that his father had told him to, and his father grabbed him by the shoulder, turned him around, and just looked at him in the eye. And at that point, Lyle Menendez urinated in his pants. Mr. Menendez then took his son down to a bedroom, and the adult followed to see what would happen, and he saw Jose Menendez. Why is it Joseph? He saw Jose Menendez strike his son, as the witness described it. A very hard blow with his fist, a 5-year-old Lyle. He was 5 years old. A very hard blow with his fist, either in the stomach or in his chest, and this upset the family member so much that he reprimanded Jose. That's not the way to be a father, and he took his family and he left the house, and he still remembers the incident to this day. He testified to that on the stand as well. I think that was Carlos Peralt, perhaps. And you will hear other examples of how Joseph Menendez brought up his eldest son. Why does it say Joseph? He he's Jose. I think it's a typo, which is very annoying because as I'm reading it, it's a distraction. All right, so, and you will hear other examples of how Jose brought up his eldest son Lyle to be, as he saw it, a lion and not a sheep. While Lyle Menendez was about 9, a cousin was visiting. The cousin, Alan Anderson, was aged 15 at the time. Alan Anderson was mad at Mrs. Menendez for some reason, some slight, so he went out and he cut off the flower heads of her flowers in the yard. Lyle Menendez and Eric Menendez were there watching, but not taking part. And Mrs. Menendez got very upset about this, and she faced Alan Anderson, the cousin, and said, "Who did this?" And he owned up and he says, "I did." And knowing this, when Mr. Menendez came home that night, she told him that Lyle Menendez had cut the heads off the flowers. And Mr. Menendez took Lyle Menendez down to the room and beat him with a belt, as was the way that he punished him at night. And Alan Anderson noticed for some days afterward the difficulty that Lyle Menendez had sitting down or walking around, and other witnesses will tell you of the presence of the belt as a means of disciplining in the house at that particular time. And it was also a family of secrecy. Diane Anderson, another cousin who spent time in the household, summers, and another occasion when she was an adult, 23 years of age, remembers very well and will tell you how whenever they went to a family gathering, she was told beforehand not to tell the relatives because no one should look poorly on the Menendezes. There should be no flaws in the Menendez children, and the family name meant everything. And she'll also tell you how during the day there was some relaxation there. There was laughter. There was playing around as kids of 9 and 10 normally do. And then when Mr. Menendez came home, how there was a sudden tightening of the faces, how there was a change in the demeanor in the playing, and the laughing ceased, and how for dinners there was the game that would now be called like Jeopardy, in which Mr. Menendez would ask particularly Lyle, since he was the one who was groomed to be the lion, current events and topics, things in the paper. And if he didn't know the answer, he had to get up from the dinner, interrupt his dinner, and go to the encyclopedia. Go find out what the answer was until his father was satisfied. This was not just, in her opinion, a learning game, an expand the mind type game, but a tool of control and of discipline. Along with the image that Mr. Menendez had for his oldest son, athletics were very important, in his case, swimming, for a short period of time, then soccer, but eventually it settled in on tennis. Tennis was the sport in which he used to succeed. And again, Alan Anderson remembers when Lyle Menendez was about 9 and Mr. Menendez had him on the court, and these practice sessions would develop into 6-hour days. And he had him on the court and he was serving to him. And Alan Anderson could see the shoulders swelling, Lyle's shoulders swelling from trying to return these hard serves that his father delivered to him. And he would keep going back and putting the racket back in Lyle's hand. And finally, he would quit and have Mrs. Menendez serve to him. But the practice session still went on. At the same time, the brothers, both Lyle and Eric Menendez, were discouraged from having any friends outside the home, particularly discouraged from having friends among tennis competitors. Because if you are friends with somebody, you didn't play as hard against them, and remember, winning was everything. I mean, this is a good, it's a decent opening so far, but he's barely getting to the meat of anything. And like Leslie's was so much more detailed and better, I would say. Um, I don't know. It's not that it's bad, it's just not really personal. And at this time, too, the brother, as Mrs. Abramson told you yesterday, Lyle and Eric Menendez, as they grew up, they bonded together. They had squabbles, as any brothers do, particularly younger brother and older brother, but they loved each other. There was one incident when Eric and Lyle were taken out in the middle of a lake by their father in a boat and then thrown overboard and told to swim ashore. And Lyle was 2 years older and had no difficulty with it. But Eric Menendez was frightened and he was swallowing water. And Lyle Menendez saw this and he swam back out from shore to help his brother and bring him to shore and to comfort him. And his father was so incensed at that Lyle Menendez had helped his younger brother that he got angry and he took them both back into the boat and had them do it again. But it's an example of the bonding, of the protectiveness, of the caring that Lyle and Eric Menendez felt for one another, even as young children. And there was a time when Lyle Menendez was about 13, 14, that he learned that his father was molesting Eric. And Lyle Menendez knew that his father had molested him too when he was 5 or 6 years of age. That molestation had stopped, but he wanted it to stop for Eric, and he went and he told his father about it, and his father promised it would stop. But instead, his father then confronted Eric and threatened him for having revealed the family secret, feeling that he had asked Lyle for his help. Well, the Mandingo philosophy, this be a lion hours of practice, single mindedness of purpose that Jose Menendez had for his son Lyle, it worked, but it only worked in tennis. Joseph Lyle Menendez became the #1 ranked player for his age group in the whole state of New Jersey, 16, 17, and 18. He was one of the top ranked players in the entire Northeast section of the United States. He succeeded in tennis. But this same philosophy that Mr. Menendez raised Lyle Menendez by failed. Oh, hold on. Let me I hate when there's like not punctuation that needs to be there. But the same philosophy that Mr. Menendez raised Lyle Menendez by failed Lyle Menendez tremendously as a person, because you will hear from the evidence that tennis being everything, winning being everything, Mr. Menendez would go to the school, the Princeton Day School, where his sons were enrolled, and make sure that the courses didn't interfere with coaching by private coaches for tennis, by tournaments that were important, that they could travel and play tennis and not miss the all important practice. And in order to bring that about, Mr. Menendez would see that Lyle Menendez's homework was done, that essays were ghostwritten for him and turned in because school is not important, tennis was. Lyle Menendez went on, and after he graduated from high school, he had a tennis coach, a man named Mr. Klaus. I don't know. Uh, we'll call him Klaus. He played tournament tennis, and the tennis coach was threatened by Mr. Menendez in early 1987 in no uncertain terms that he was just to babysit Lyle Menendez now in tennis. He was not to encourage him to go on to a career there. He was to babysit him in tennis because Lyle Menendez was to go to Princeton University. The coach took the threat seriously and told Lyle Menendez about it in the tournament. He felt that his safety was jeopardized if they went on without development in tennis and that Lyle Menendez's safety was jeopardized. When Lyle Menendez heard about this, he did something he'd never done before. He quit in the middle of a match in which he was holding his own. He told the other player, "Go ahead, put up a score," and left, and went to Princeton, started in I think it was the fall of 1987. He was very ill-equipped for Princeton University, and in his first semester there, he didn't do well, and he was asked to leave, and he could try to return again in a year. So he did. He left and he re entered. He re entered Princeton in February of '89, and that's when he befriended Donovan Goodrow, the person whose license was used to buy the shotguns later on. He befriended Donovan Goodrow, who was working in, I think it was a TGIF restaurant there, and Donovan Goodrow told Lyle Menendez that he was going to be a Princeton student. He was just waiting to enroll there. He was going to take classes, and Lyle actually had him move in. He shared Lyle's room there on campus at the time, and for 2 months, 2 or 3 months, they were inseparable friends, sharing thoughts, ideas, goals. Lyle Menendez allowed Donovan Goodrow to use his student ID to go get meals on the campus. So Donovan Goodrow would use Lyle's ID to go get meals on the campus there with his meal ticket. He paid his way out to Los Angeles to meet Mr. and Mrs. Menendez to get their approval for his friend. And knowing how hard this would be, he worked with Donovan Goodrow. They went over and over the examination that Lyle Menendez knew his father would give him at the dinner table as to his intentions, who he was, where he was going, because Lyle Menendez wanted his friend to be accepted by his father and knew how hard this would be. And it was a disaster. It didn't go well. Mr. Menendez did not like Donovan Goodrow, did not feel that he was acceptable for a lion to associate with. He was a sheep, and so he began to discourage that friendship. When they returned to school after spring vacation break, when they'd been out here to Los Angeles, Beverly Hills area, some of Lyle's friends, including Glenn Stevens, that the district attorney mentioned, found out that Donovan was a fraud. Donovan was not going to be going to Princeton University, and they came and they told this to Lyle Menendez. "Get him out of here. You've got to get him out. He's not our kind," and Lyle Menendez resisted this. Donovan Goodrow was his friend, and then the calls came. Eventually, a call from his father ordering him to evict Donovan Goodrow from that room. And so there were tears, and Lyle Menendez did kick Donovan Goodrow out. And Lyle Menendez's friends, including Glenn Stevens, loaded Donovan Goodrow's truck up and he left. And he left behind his wallet to California licensing. When Donovan Goodrow drove away, apparently he had a sweater or some other things of Lyle's, possibly owned Lyle some money. He divorced or sorry, he discovered his license was missing, but he never tried to get it back. His bank card was missing too, but his bank card was never used by Lyle. And the wallet was next seen on the floor of the dorm room. When Teresita Baralt, Lyle Menendez's aunt, who lived in Princeton, came and helped him clean up the room, which apparently looked like most 20-year-old men's rooms would at the time, and he found the wallet on the floor. They took it with the identification. Now, that identification was then provided to Eric out there in California as an identification because it gave the age where you could use it. It was a California license. He uses really weird phraseology that doesn't necessarily make sense. It's like if you didn't know things about the case, you wouldn't understand what the heck he's talking about, to be honest. I don't know if I particularly like this opening statement. It's so unfortunate that Jill Lansing didn't stay on for Lyle. So it says it was a California license and it was really used in the purchase of the shotgun because to get a shotgun, you had to have a California residence identification. Lyle Menendez had a New Jersey was all that wouldn't do. So Lyle Menendez had a New Jersey ID. Eric Menendez's California license was suspended, and so this was the identification that was used to purchase the shotguns. He did not say like explain that in a concise way. He says you'll learn too the shotguns, even though purchased, you will find in the San Diego area, and even though Donovan Goodrow's name was signed to match the license to fill out the ATF forms, that there was a camera there right above the counter. Looked for all the world like any surveillance camera that you could see in the place taking photographs. Now it turned out from the evidence it was a dummy. Kmart or Big Five, whoever it was, didn't spend the money to have a real camera there, but it didn't look that way to the purchaser coming in. It looked like a real camera that recorded transactions. There was no attempt to hide the face or disguise things or anything like that with what looked like the camera there. We came up to later in the summer to August and the Kalamazoo tournament that Mr. Khan mentioned. Eric Menendez was playing in. This was a national tournament for the age groups, 16 group and the 18 group at that time, and there was a discussion about a camcorder that had been purchased. Camcorder was there, and Lyle Menendez never kept that secret. He told Detective Zoeller about what he talked to him in Princeton in September. What he told Detective Zoeller about that when he talked to him, sorry. Um he said, "Yeah, we had an argument about the camcorder, but my dad always came around when he saw that it was something that we really wanted. And the camcorder was very useful for filming tennis matches, for filming Eric's tennis matches to help find out what flaws were there or other things in the game. And in fact, you will hear that Kitty Menendez did use the camcorder, as did Eric and others. But at the same time that there was this argument about the camcorder and what it might have cost, at the same time, Lyle Menendez, from a material standpoint, never had it so good. He was going back to Princeton in September with all the tuition that it costs to go to Princeton. Right, sorry for the interruption. I'm just going cameraless because my hips are hurting and it's hard to sit up. So, continuing on, the family was purchasing a 2,000 square foot condominium for him 2 miles from campus that had been picked out by his Aunt Teresita, who lives there. That condo had already been arranged to be purchased and the closing was set for September 4th. His plans had been made to purchase furniture for that condo. Mrs. Menendez was going to go help take care of that on September 9th. So the homicides took place on August 20th. So shortly thereafter, they would have been going and setting this condo up for Lyle had the homicides not occurred. Lyle Menendez had a car to take him the 2 miles to school or anywhere else that he needed to go. He had clothes for school at that time, not suits and ties, but the clothes that you wear to an Ivy League school, with all the clothes that he wanted or needed. He had money to buy presents for girlfriends or friends of any kind, and he did. And he also knew he was disinherited. He'd been told a year before, he and Eric Menendez, that they were out of the will. And there will be much evidence of this from Carlos Baralt. Even I think the tape recording of of this conversation you're going to hear. Dr. Oziel, even he knew about it and made a reference. You will hear to them being disinherited. So, at that particular time in August 1989, Lyle Menendez never had it so good. From a material standpoint, he had possessions, furniture at Princeton, from all that you could want in your 21 years of age. And he never had so much to lose if his parents should die, because his Princeton uh this this Princeton and the condo and the clothes and the money, that was only there if the parents were alive. If they were disinherited and money went under a will, that all went away. So there was no incentive financially for them to actually take their parents' lives, as we can see. But you will hear evidence that there was more than just the material comfort at work at this time. Because although there was the condo and the car and the clothes and Princeton, at the same time, Mrs. Menendez, for the whole semester, the spring semester that had just ended at Princeton, had called Aunt Terry, as the family calls her, Teresa Buralt, daily. She called her daily to check up on Lyle and had repeatedly asked Mrs. Baralt to get an extra key to the condo so that she could go over and let herself in and see what Lyle was doing and what he was up to. So she's like, I can't spy on my son, but would you? I can't spy on him from California. Now you will also hear when there is evidence presented about this last week before the deaths, as Mrs. Abramson told you yesterday, about the fear that was still present in both these young men, and why, when they talked to each other that last week, they couldn't just leave. And they both wondered, how do mom and dad know everything we're doing? How do they know our secrets? How do they know things we never told them? We can't get away. They know everything we do. They know everywhere we go. They even talked seriously about whether their mother was a witch, because she knew so much about what they were doing. And it was only after the tragic events of August 20th that they found the tape recorder that had been placed by their parents on Eric Menendez's phone in his bedroom, and the tapes that the parents played so that they knew everything Eric was talking about to his friends or to other people. And this is where their superior knowledge came from that caused so much fear in both of these young men. They were being spied on by their own parents. Literally, their conversations were being recorded. I'm not going to repeat all of the events of the last week. Mrs. Abramson did a very thorough job of that as to what the evidence will show concerning that, except one event on Friday when they were going down deciding what to do and ended up buying the shotguns when Eric Menendez confided in Lyle the details of the molestation from the physical aspects of it from his father. And Lyle Menendez, for the first time, confided in his brother that he too had been molested when he was young, and they both realized what a grave family secret this was that they were carrying around with them. And it was that fear of that family secret and how much Mr. Menendez and Mrs. Menendez would do to protect that secret that caused this terrible fear on Sunday night. It was then, when Mrs. Menendez had said they'd ruined the family, and went in the den and closed the door. After all the other events of the week and of the day, that Lyle Menendez freaked out, he panicked, he ran up the stairs where Eric Menendez was, said, "It's happening, they're going to kill us." And that's when they went and frantically loaded the shotguns and they came back into the room. And as you see the wounds, you will see evidence of wounds, evidence of shots, the number of shots that were fired from those two shotguns that night. Each wound, each shot speaks of the fear that was going on when those shots were made. And you will hear, I like that. I like that take. Each shot is a physical representation of how much fear they were in. So the more shots they did, the more afraid they were. That I kind of like that analogy there. All right, so and that's not really an analogy, but you know what I mean. And you will hear from the coroner's office, from the medical examiner, from other medical doctors, the aim of overkill that was involved here speaks of the fear. So that's a term. I don't know if they use that so much in the first trial, but just the fact that they, you know, shot them so many times when, not as just a one or two bullets per person probably would have been sufficient. Well, come 10:15, shots have been fired on a summer evening. Shotgun shots, small room in the Beverly Hills home. Lyle and Eric wait for the police, feeling obviously they'd been heard. So we've heard that before, that the brothers they've testified to this. They thought that the police would just show up automatically after hearing the gunshots. They thought somebody would call the police. Um, so the shots were heard, but nobody called, and the police didn't come. That's when the cover up began. No police coming. They did go pick up what they saw of the shotgun shells, took them out, tried to come up with an idea as to how they could cover their whereabouts, ran down, got the movie stubs for the sold out movie, so that didn't help them. They'd missed Perry Berman, so they tried to go to the get rid of the guns and try to still catch him at the Taste of LA, but it was too late and they called him. He agreed to meet them at the Cheesecake Factory and then they lost it. Eric and Lyle lost it because now they realized when they went in and they picked up the shotgun shells the tremendous mistake they had made. They knew that their parents had two rifles in the house, and that's what they thought was waiting for them in that room. They were going to come out of the room with the rifles, and when they went to pick up the shotgun shells, they saw there were no rifles. They had made a tragic mistake as to what they thought. This is new. This is a different theory, and this might just be the defense attorney's spin on this. I don't know. Um, Saying that they realized they made the tragic mistake as to what they thought their parents were going to do because of the tremendous fear that their parents had always engendered in them. With this mistake came tremendous grief, tremendous remorse, and that's why you will hear they did not go meet Perry Berman at the Cheesecake Factory, but they went home. And this very shaken 911 call that you will hear was made and the statements made to the police were genuine emotion. It's true, they did not tell the police the truth. They tried to lie their way out of it at this point, both as to the reason that the killings occurred and as to who did it. But what they did not do, and what Lyle Menendez did not do, is to try to pretend that this was a mafia hit or an organized crime hit. You will hear the tape of the conversation with Sergeant Edmonds on the very night that this happened, and it was he who was saying, "Do you have any idea on this that's going to help us? Do you have any idea on this that's going to help us solve it? If there's any problem, we've got to solve it." And it was at that point Lyle Menendez said, "One of my concerns is I don't like any bad press about my father now." He did not talk any organized crime then. He did not talk about business associates. And the police officer then said, "Well, we want this person or these people, whoever did this, to answer to their crime. So you've got to help us." And you will hear, as you follow in the transcript, that about 2 pages went on while Lyle was ruminating and talking about it, not not looking like a burglary. Okay, so Lyle was talking about it not looking like burglary, and then he finally says, "Well, he's in a business where there's little small companies and they're being squeezed out and they're going down, and my dad is a pretty ruthless businessman and he believes in the bottom line and we've laughed over stories of him trying to push these guys out. So, it might be business related." And that's where the business related, and I want you to listen carefully to the tapes when you do hear them in the transcripts that you follow because that's where the business related idea came up after repeated urging by the police officer to come up with something. And in one sense, Lyle Menendez later says, "We've had some problems with gangs in the past. In the last year and a half, 2 years, my brother was beat up." And that's given equal significance in his statement with the statement about business associates. And in fact, when Detective Zoeller goes to New Jersey and talks to Lyle Menendez. I think it was September 17th, and you will hear that conversation also. And Lyle Menendez is apparently trying to discourage his organized crime thing. And Detective Zoeller says, talking about the coroner's office, as far as we know, of course, we trust them as far as we trust anybody, but they initially came out and said, oh, it looks like an OC hit, and so on and so forth. And Linehan, Detective Zoller's partner at the time, said organized crime, and Detective Zoller says, yeah. And that was their belief. And just a couple of pages later, when Lyle Menendez is asked about it, so it was the cops that originally said organized crime. Um, when asked about it, that was their beliefs. And just a couple of pages later, when Lyle Menendez is asked about it, he says, because, I don't believe the organized crime thing until I see something. He wasn't pushing organized crime with the police. Or the investigators. He was denying it as being a theory. So he didn't come up with it, and he denied it on its face when the police suggested it. There will be some witnesses who will say these are civilian witnesses who will say, well, he was playing up he was playing up that it might be mafia or organized crime or something to them, but not to the police where it counts. They're the ones who are doing the investigating. That's a weird sentence there. Then we've heard, and you will hear, evidence about a computer, or, yeah, a computer will, whether or not there was a will that had been changed, and that Joseph Lyle Menendez was trying to destroy any evidence of that will. Well, you'll hear that on the very day or two after the shootings, the lawyer Randy Wright and his wife talked to Lyle Menendez and Eric Menendez in their home, and the lawyer, hoping to be executor of the will, asked questions about where the will might be. And in response to that, Joseph Lyle Menendez said, well, we have a safe. It might be in that. And it was Mr. Wright, the lawyer, who said, well, you should bring the safe over here and then we can open it in the presence of the executor. And that's what Lyle Menendez did. He went and he got the safe because he was directed to be the lawyer, and brought it over to his house thinking he was directed to by the lawyer, and was brought over to his house thinking that that was the will that had disinherited him, because that's what he heard. That's what he had heard, and that's what he had thought from Jose. Now you will hear from Marta Cano, another relative, a businesswoman in the family from Florida, who was very close to all the family and their finances and affairs. And she was here, as was most of the family, for the first memorial service that they had here. And so while she was here, she decided that she should make herself busy and investigate affairs of Joseph Menendez, of Jose Menendez. Jose, not Joseph. Stop that. Of Jose Menendez, as to, I think it's the transcriber who is like accidentally spelling out Joseph the whole time, because his name was not Joseph. I'll look into this. Hold on one second. Let me double check. Yeah, I'm not finding anything. He's definitely a Jose, and I think it's just the transcriber who keeps accidentally misspelling it, because there's Lyle, no, it's Lyle Jose Menendez and just Jose Menendez. So I don't know. It's an error, and it keeps tripping me up when I'm reading it, and I don't like it. All right. So she decided that she could make herself busy and investigate affairs of Jose Menendez as to the company where he worked, insurance policies, what the family financial affairs would be. And then, as she doesn't know if it was a Wednesday evening or a Thursday evening, it was one of the two. She called the boys, Lyle and Eric, together and said, we have to talk. You've got to know where you stand. And she said, Now, first, there's this $650,000 life insurance policy with Sun Life. And they said, huh? She said, well, I personally took that out. I brokered it. And I know that exists, and I'm going to put the claim in for that. And both Lyle and Eric Menendez said, no, Aunt Marta, no, you don't understand. We've been disinherited. We don't have anything. And she's the one who told them that's nonsense. I remember when the will was written, I witnessed it and did this policy, and you're all right. And both Lyle and Eric refused to believe it, and they said, no, no, that's not true. But as of August 20th, 1989, all of the evidence will show that both Lyle and Eric felt they had nothing coming from a will or insurance policies, that if their parents died, there was no money. And it wasn't until 3 or 4 days later that they learned there might be. The will was the safe was later opened. The executors were present. They were a couple of steps, 2 or 3 steps behind Lyle and Eric, not out of the room because again, Lyle and Eric Menendez wanted to make sure there were no family secrets that were revealed and they knew what the family secrets were. There was no tearing up of a will or new will or concealing of it. There just happened to be nothing of value except the key in that safe. And the same thing with the safety deposit box. There was no destruction of documents, tearing them, or anything of that nature. But there was a computer in the house, and Carlos Menendez and another relative, Brian Anderson. So, Brian Anderson is the brother of Kitty, who is not for the brothers coming out of prison right now. He also sued the brothers for money, for, the parents' money and stuff. So that just goes to show kind of where his head's at. So there was a computer in the house, and Carlos Menendez and another relative, Brian Anderson, an uncle from the Chicago area, they went there and they tried to call up the call words Will and Menendez, and I think one other, and played with the computer trying to bring up whatever was on it, and they were unsuccessful. And while Carlos Baralt, the uncle from Princeton, was telling Lyle and the others, well, a computer will's not valid, that's got to be witnessed. That's nothing. But Carlos Menendez didn't want to let it go, and he asked another relative, Marianne Cano, also in New Jersey, to get an IBM expert to go into the computer and see what they can find, and they did. She got an IBM expert and had it all set up. And then Carlos Menendez said, never mind, I got my own expert. Considerable distress to Marianne Cano, who had gone to the trouble and put herself on the line to get an expert, but Carlos Menendez was going to have his own expert go out and do something with the computer. And this, do you, back in the 90s, we had no idea what computers were. He's like, he's going to go and do something with a computer, not like go and find, deleted files or whatever, common language that we use now. He's just like, I'm not going to bother explaining what they're doing because I have no idea. They're just going to do something with the computer. And this now made Lyle Menendez suspicious, and he flew out to LA and got the man that the district attorney has told you about, Howard Whitkin, to go and to look at the computer. And Mr. Whitkin got there. He looked at the computer and he tried to retrieve what was there. Then he said, there's nothing there. There are only a few characters to begin with, and they've been typed over somehow, so there's nothing that's even retrievable. There's nothing on the hard drive that can be even that we can get, even if somebody had said delete the file. So even if somebody deleted it, they can no longer retrieve it. It's been destroyed. So at that point, he says, Mr. Lyle Menendez said, well, then just wipe it clean so that nobody can get whatever is in that computer. And then, if you can, make it so nobody knows you've been here. Lyle Menendez then paid the man with a check, which bounced, and it's still available. The check. Um, I guess they're going to show the check as a receipt or something. He left the receipt that Mr. Whitkin gave him in plain view by the television, where Mr. Whitkin said that he left it, and where it was still there 3 months later for the police to find on the easiest search warrant they've ever executed. There was no attempt to hide that transaction. And as to the spending, there was no attempt to hide that either. When Lyle Menendez went and got the Rolex watches, he did it on a credit card that had a $250,000 credit limit that I believe had his father's name on it. They had to check as to whether he was an authorized buyer on it or not. He stayed there while they did that. He even because this was a big transaction, they allowed him to make a telephone call right from the counter there, right in the presence of the person who sold him the Rolex watches. And he stated, or he called his uncle, Carlos, the executor of the estate, to see if this was appropriate, and they talked about whether or not he should wear it to the service, the second service that they had, a funeral service back in Princeton, New Jersey. Okay, so he ran this by Carlos Baralt. We didn't know this then in the first trial, but this is insane. He ran it by Carlos, and we're still asking, or the state is still saying that these are just a bunch of greedy rich kids trying to take their parents out for money. Yet we know that these Rolex watches that the state keeps trying to spin as some like nefarious act was now um, uh, run by Carlos Baralt, who obviously approved of the purchase. This is insane. I really think that there should be legal action that you can take for a prosecutor trying to spin a narrative that is provably false. Provably false. This is a narrative that the state has spun. And of course, the state has all the power and the resources and the news outlets that listen to them. And that's the news, or that's the narrative that the state has spun from the very beginning, that these were rich, bratty kids that just did it for the money. I mean, it makes me so angry. And when he bought the Porsche, which he did, and went back to New Jersey, he sought the advice of everyone around him. The bodyguard, Richard Wenskowski, who he knew only for a week, and again his friend Glenn Stevens, who he had with him and when he test drove it and went there. So he's asking everybody's opinion because he doesn't want to rush into a decision. And so he's asking the opinions of other individuals around him, even the bodyguard who he's only known for 1 week. So I like that. I find that really charming about Lyle. Like, should I buy this Porsche? Like he's really excited about it and he wants everybody's opinion. All right, so he also lent Glenn Stevens one of those Rolex watches to wear, and Mr. Stevens was still wearing it when Lyle Menendez was arrested. Okay? Glenn Stevens, who I believe he testified against the brothers in the first trial and possibly even will be called again. I can't remember if I saw him. I think I did when I was going through all the transcripts. And Mr. Glenn Stevens sold the watch to a jeweler and never gave any of the money to Lyle. This isn't news. Like, this isn't the first time we're hearing this, but this is kind of, I think it's important to note that Glenn Stevens has some other, um, maybe some other intentions because he went and sold the watch and never gave it back, never gave the money back to the brothers. So, and then there was a business, the chicken wing business in Princeton, New Jersey, the Buffalo Wings. They changed the name of it and invested $500,000. I think I think was the purchase price and about 300,000 or so down payment, and he had to go again through the executor. He worked with Carlos Baralt, his uncle, on this as to whether it was a good thing to do. went over and checked the place out. They overpaid for it, it turned out, but that this was done with Mr. Beralt's consent and checking into it, and thought it was a good idea for Lyle to have a business, something to keep him busy, something to keep him occupied because he'd always been interested in business. At the time that Lyle Menendez was arrested, he entrusted the running of that business to Glenn Stevens, who was wearing the Rolex watch. And in a short period of time, the business went under and it had to be returned to the owner and it failed. So, was that partially because of Glenn Stevens and bad management from Lyle, perhaps? I don't know. So, as to the condominiums in the New Jersey area and the property that Mr. Khan mentioned, Lyle Menendez went and talked to the people there about buying a larger condo than the one that he already had in progress for him that was going to close on the 4th. September 4th, on the feeling that his brother Eric would be joining him perhaps at Princeton and they'd have some place that was large enough for the both of them. And he went and he put down, I believe, some deposit money and it never went through. He didn't buy the property. That's an interesting tidbit I didn't realize was that he was trying to get a bigger apartment because he had planned for Eric to come join him out there. What happened is that Eric Menendez decided to go east, but to stay in California and work on his tennis career. And so that's when they went and looked at the property in Marina del Rey. Again, talking about a $990,000 penthouse or something, but they didn't buy that either. They rented there. And the reason that they chose Marina del Rey was because it had the facilities. It had the health club facilities, the weight training facilities, the tennis courts that Eric Menendez needed in order to further what was going to be a professional tennis career at that point. Then we get to the statement made to Dr. Oziel, which you will also hear the tape recording of, I'm sure, with a transcript to follow along. And Mr. Khan read you some excerpts from that about thinking it over and sleeping on it for 2 nights, planning in effect to take the parents' lives and doing a mercy killing for the mother. You have listened, or you have to listen carefully to that tape when it's played as to how these statements come about and the context in which they were made. And you will find that for the first 2/3 of the tape, it's Dr. Oziel who's doing most of the talking, most of the suggesting, until finally at the end, Lyle goes ahead and runs with the ball and says some things to get it, or he says some things just to get it over with. But some examples that you'll hear when this is played to you as to the mother's self deletion early in the conversation, you'll hear Lyle Menendez talking about it. I couldn't tell my aunt what are we going to do about my mother's self deletion thing. I mean, it was you couldn't do anything like that. And this was a self deletion thing that had occurred 2 years earlier when she left what appeared to be a note, and she'd also had an overdose of some pills for which she was once taken to the hospital. So Dr. Oziel takes that and he ran with it. And you'll hear Dr. Oziel shortly afterwards saying, "Well, when you ended up taking your mom's life, did you feel like you were sparing her? I know she was horribly depressed and totally dominated by your dad. She was like a shell of a person. She had no identity or strength left anymore. I know that you had been responding to her as I think almost like a person that's become sort of pitiful. That's a strong word, but is that how you felt?" Those are Dr. Oziel's words concerning a mercy, KI double Lling, or a self deletion or pitiful. Shortly after Lyle Menendez answers, "When I found out about the first note, then it got worse and worse, but that was okay. I'll now support my mother. And Eric and I decided we would rally behind my mother." He goes on, "I'm going to rally behind my mother, and I said I had a conversation with her, and I wrote her a long letter saying if she ever wanted to leave Dad, she could move to Princeton. I'd live with her." This is Lyle Menendez talking about his mother. And again, we get back 4 pages later to Dr. Oziel, and Mr. Oziel is the one saying, and you ended up trying to protect her and getting punished and rejected. And as a person, you're getting told you're a bad guy. When really what you were trying to do was save her from what your dad was doing to you and your mom. I mean, that's what I'm hearing. That's Dr. Oziel suggesting here. And then this will be throughout this transcript, you'll hear Dr. Oziel prompting and saying things about the self deletion and saving her because it was the merciful thing to do. And then Dr. Oziel starts to talk about control, and it's Dr. Oziel saying, it's obvious to me that he was doing all kinds of stuff, talking about Father Jose. From totally controlling everybody in the family, being completely cold blooded about his decisions, considering everyone as sort of an instrument of his own will. And there's a lot of stuff that your dad was doing, including talking about disinheriting. You actually have said that he did disinherit you, I guess, at a couple of points. And Lyle says, that didn't enter into it too much because I felt like Eric and I could handle it, that he would expect us to handle it. Even there, the disinherit is coming up. And Dr. Oziel is then saying he trained you by being a disciplinarian, by being tough, not by having a loving bond with you. Lyle Menendez says, I felt the bond though, you know. And then 2/3 of the way through the conversation that you will hear Dr. Oziel say, well, even while she was being totally destroyed by him, that he was blocking absolutely even your love for her and you're trying to help her. And especially you, Lyle, here you were loving her and trying to care for her. And instead you get blamed for it. And there was an absolute denial of what was happening, and yet you knew the pain she was in. You saw her totally deteriorating, and it's almost like, I mean, your love for your mother was, and the pain with her getting just totally brutalized over all the years. Well, like it was a lot worse than the pain you went through being with your dad. You thought you could deal with your dad more than your mother. Your mother couldn't deal with your dad. Your mother had no way to deal with your dad. He might be one of the worst therapists on earth. That's all Dr. Oziel talking. And then you will hear Lyle talking about, yeah, okay, we did it because it was the merciful thing to do. So he kind of just acquiesces at the end there. Finally, we get to fear. Even after the shootings, even after the tragedy of August 20th, the fear of who's going to believe me, who's going to believe these things happened in the house. And so he made a mistake. He asked a girlfriend to say that his father had come onto her. So this happens after the first trial. Okay, so Lyle was busted, I think, over recorded telephone conversations in prison that he was trying to get people to maybe change their stories on the stand and to say that Jose did things to them so that they had a stronger case, which obviously is wrong, obviously not the right thing to do. Um, but he's also a kid still, and he was trained by Jose to be ruthless in everything he does. So you got to give him some grace here. So we get to this conversation. Who's going to believe these things that we did? And so he made a mistake. He asked a girlfriend to say that his father had come on to her. And she said, I'm not going to do anything like that. And that's when Lyle Menendez said, well, I told my attorney you wouldn't. And as the district attorney said, that was not either Mrs. Towery or I who are now representing Lyle Menendez, nor was it Jill Lansing, nor Michael Burt who represented him in the last trial. This occurred before that. So this was okay. So he wasn't even being represented by Jill or Burt, Lansing or Burt at the time yet. So um, it wasn't between. No, I really thought it was between the first and second trial. Maybe it was ruled not to come in the first trial, but for some reason they're allowed to talk about it in this trial. I don't know. It's very strange. And even after that, after she said, I'm not going to do that, she will testify that the next time she saw Lyle Menendez is when he held up this yellow sheet of paper for her, putting his life in her hand and saying, I did do it. I did take my parents' lives. If it was because my father was molesting Eric and mom molested me, he didn't say the fear, but he did have in there what caused some of the fear. And at that point, Jamie Pisarcik didn't accept it and ran out. But even after saying she wouldn't lie for him, he entrusted his life with her or to her by telling her the beginning of what had happened. Please listen carefully to all the evidence that is presented by direct examination, cross examination, tape recordings, any means in which either side presents evidence to you. I think you will hear the essay by Mr. and Mrs. Menendez in this family, the control in all the phases of Lyle Menendez's life by Mr. and Mrs. Menendez. You'll hear that Mr. and Mrs. Menendez were pretending to have these supernatural powers to know everything that was going on as a controlling mechanism, and that they really learned it through bugging the phone and other means. So they were literally spying on their kids. But that those statements that very fear that okay, but those statements, that very fear that Mr. and Mrs. Menendez engendered in their sons by pretending omniscience, by being all controlling, by not letting them develop the skills to have good judgment, is what caused this uncontrollable fear on Sunday night, August 20th, and ended up in the tragedy of their demise. And he says, thank you. The court says, all right, thank you. I'll remind you that the comments of counsel and opening statements are not evidence. Not, you have yet to hear any evidence of the case. We'll take a recess now, and afterwards we'll begin taking testimony. We'll resume at 25 minutes at the hour, approximately a 15-minute recess. We'll see you back here. Then don't discuss the case. Blah 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 blah. Okay. the jury, the jury leaves. Miss Abramson says, Judge, do you want to take up complaints now or do you want to wait until the end of the morning session? We have a series of them. The court says, okay, unless it relates to what's happening right now, I don't. She responds, thank you. I'd ask the court to reserve a few minutes before the lunch break. The court says, all right, we'll have some time to deal with that. Ms. Abramson says, thank you. The court says, let's get the jury out. The jury enters the courtroom and the following proceedings were held. The court says the jury is back. Having completed opening statements, we will now proceed with the taking of evidence. The people will call their first witness. Okay. Mr. Khan is going to be calling detective, sorry. He says, yes, people call Detective Les Zoeller. So Leslie Zoeller was called as a witness by the people, was duly sworn, and testified as follows. The clerk, you do solemnly swear that the testimony, okay, blah, blah, blah. He's sworn in. Direct examination begins. Wait, I keep saying Dr. Khan. I'm sorry. I don't know why. Because we kept doing Dr. Oziel. By Mr. Khan, here's the questions. Sir, would you say that what Sir, could you say what you do for a living? I'm a police officer for the city of Beverly Hills, assigned to the detective division. And are you one of the investigating officers in this case? Yes, I am. How long have you been a police officer? I've been a police officer for 22 years. And during that 22 years, have you spent the entire time working for the Beverly Hills Police Department? No, I spent the first 3 years working in the City of Gardena Police Department. And the following 19 years working for the Beverly Hills Police Department? That's correct. And what is your rank and assignment at the Beverly Hills Police Department at this time? My rank is police officer assigned to the detective division, and I work with the robbery homicide detail, which I've been working for the past 16 years. Does that mean you were then assigned to the detective division back in 1989? I was so assigned in 89, yes. And did you previously testify in regard to the case both before the grand jury and in superior court? Yes. And have you had an opportunity to review your testimony? Yes. Now, were you working on in the early morning hours of August the 21st of 1989? I was not on duty at that time. No. Okay. And were you called and notified at that time? Yes, I was called at home. And upon receiving that call, can you tell us what you did? I immediately came into the Beverly Hills Police Station and waited for my partner, Detective Linehan. And at that time, he and I both responded to 722 North Elm Drive, Beverly Hills, to the scene of a reported homicide. The court says, let me inquire, can the jurors see the witness? And all answered in the affirmative. Okay. Mr. Khan continues his questioning. At this time, I would like to show you an exhibit which depicts 4 photographs of a residence, and I would like to mark the exhibit as People's 1 for identification. Court says, all right, let's do this with exhibits for all sides. Please indicate whether or not it was an exhibit in the first trial and what the number was in the first trial. Mr. Khan says, yes, the exhibit, Your Honor, was not an exhibit in the first trial. The court says, okay, then we'll be starting off fresh with new numbering, but I don't want the old numbering to be obliterated. So can we keep track of what an exhibit was if it was referred to in the first trial? All right, this will be Exhibit 1. Um, Mr. Khan says, okay, showing you what has been marked as Exhibit number 1, I would like you to identify what it is that you see in each of these photographs and let me give you the pointer to assist you. And you may step out of your seat if that is necessary for you to reach. The Exhibit 1, each photo is a different angle in aerial view of 722 North Elm Drive in Beverly Hills. This is the house. This is Elm Drive. I'm referring to photograph B in Exhibit 1. This is Elm Drive, which I'm pointing at, the house itself. The front faces in a westerly direction. It has a tennis court to the rear, a guest house to the rear, a swimming pool. And in this photo, you can see just a glimpse of the alley that runs behind the house. This photograph, photo A of Exhibit 1, shows the front of 722 North Elm, which I'm pointing to. It also shows the guest house, swimming pool, and tennis court. Photograph C is from the north looking south, again, an aerial of the house, which I am pointing to. And photograph D is from the south looking to the house in a northerly direction. Again, this is the house, this being Elm Drive and the alley. All right, thank you. You may return to your seat. Now, can you tell us what time it was that you arrived at the residence of 722 North Elm Drive? It was approximately 1 o'clock in the morning of the 21st. And your partner, Detective Linehan, was he with you? Yes, he was. At that time that you arrived at the location, were the defendants Eric and Lyle Menendez at the residence? No, they were not. Were there patrol officers there at the time? Yes. Would you describe the crime scene I'm talking about, the exterior of the crime scene at the time you arrived? So, by the way, just FYI, the police were called sometime after 10 o'clock, I believe, is just when they finally arrived home and they called the police. So, for the lead detective to show up after 1 a.m., there was a lot of investigating already happening before the lead detective shows up. I just want to point out there. All right, so the exterior had a yellow police tape around the front of the house and around the rear of the house at the alley, and there were police officers keeping people away. Okay, can you tell us what is the role of patrol officers in protecting the integrity of the crime scene? The role is no more to make sure that it stays in an undisturbed manner until the arrival of detectives who will take over the crime scene. And as the investigating officer in this case, did you ascertain from the patrol officer or anyone else as to whether there were other residents at the location at the time or whether other persons who resided at the residence had been at the location earlier? Yes. Ms. Abramson objects, calls for hearsay. The court says, overruled, the answer will stand. Mr. Khan says, okay. And did you make any attempt at that time to interview any persons living at that location at that time? No, I did not. And did you have an understanding as to whether or not other persons would be interviewing someone? Yes. And what was your understanding? Ms. Abramson objects, calls for hearsay, court sustains it. Mr. Khan says, at that time, what role did you undertake in the investigation of this crime scene? I was the lead investigator of the crime scene. And what duties does that entail? To direct the Crime Scene Identification Bureau for the Beverly Hills Police Department through the crime scene, looking for evidence, be it latent prints, physical evidence, direct photography equipment, and so on. So, when you use the term Identification Bureau, what are you referring to? Beverly Hills Police Department has an identification bureau and they possess the crime scene, or they process the crime scene. They do fingerprints, collection of evidence, photographs in this case, a videotape of the crime scene. And is part of your responsibility also to interview any witnesses? That's correct. Did you interview any witnesses that evening? The only witnesses that evening were the police officers that were first on the scene. And did you assign any other persons to interview the witnesses? My sergeant or my boss, Detective Sergeant Tom Edmonds, was already interviewing the defendants. And was that at the crime scene? No. They were transported to the Beverly Hills Police Department and interviewed there. And did you order the taking of the photographs at the crime scene? Yes. You also indicated that you ordered that a video be produced of the crime scene? Yes. Did you supervise the collection of the evidence from the crime scene? Yes. Did you have an opportunity as part of your investigation to inspect the full premises extending from the point of the property to the front of the property to the rear of the property? Yes, I did. Mr. Khan says, at this time then, I would like to show you a second exhibit which was not previously used in the first trial. Your Honor, this is a diagram of the interior and exterior of the residence. May this be marked as Peoples 2 for identification? Court says yes. He continues his questioning. At this time, I will place on the board a diagram which has now been marked as Peoples 2 for identification. If you would, I would like you to identify and describe what it is that you see in this diagram. This is the residence at 722 North Elm. This is the north direction, southeast and west pointing. The north of the entrance is where it's indicated, and this is the ground floor only. It's not the second floor, and tennis court, guest house, and the pool. Okay, you may return to your seat for the moment. Thank you. Let me at this time show you some photographs at the crime scene. I would like to mark this Peoples 3 for identification. May it be so marked? The court says yes. Ms. Abramson says, we are marking differently for prosecution and defense exhibits. The court says, I haven't decided that yet. My feeling is we'll probably do the same as we did in the first proceeding. Ms. Abramson says, that's just the court. Exhibit 3. Thank you. He just loves to cut her off. All right, Mr. Khan continues his questioning. I'm showing you what has been marked as Peoples 3 for identification. Can you tell us what that depicts? It's a photograph taken from the photographer standing on Elm Drive looking at the front of 722 North Elm. Once again, referring you briefly to the diagram that has been marked as Peoples 2 for identification, can you tell us where it is that we are looking at this particular photograph? The photographer is standing just about where the 70-foot mark is on Elm Drive to the far left of Exhibit 2. All right, and showing you another photograph that I have at this time, I hold in my hand a photograph of what appears to be the rear of the property. This was previously marked as People's 387 in the first trial. May this be marked as People's 4 for identification? The court says yes. Showing you People's 4 for identification, can you tell us what it is that is depicted in that diagram? I mean, this photograph. I'm sorry. It's a photograph of the guest house and pool with the tennis courts at the left of the photo. Okay, and can you tell us if they're in the rear of the property as you are looking back toward the rear of the property, there is a gate at that location? Yes, there's a wooden gate. Okay, so both the front of the property and the rear of the property have gates, is that correct? That's correct. All right, let me show you some more diagrams at this time. Did you go inside the residence with your partner? Yes. And at the time that you went inside the residence, were there other police officers inside the residence? At that time, no. Your Honor, I have a diagram here which was not previously used in the first trial. It is a diagram of the first floor of that residence. May this be marked as People's 5 for identification? The court says yes. At this time, I would like to direct your attention to what we have just marked as People's 5 for identification. Now, can you tell us what is depicted in this diagram? The diagram is the ground floor of 722 North Elm, and it seems to depict it as I observed it on the night, or I'm sorry, early morning of August 21st. Okay, and I would like you, if you would, using the pointer to please indicate the various rooms on that first floor. The entrance is to the far right, to the far side, which comes into the entry to either the foyer, either side of the entry is to the left, the study or north of that. To the south is the living room. Further into the entry to the left is a small closet, and then the dining room area and a bathroom to the right. There is a den directly east of the entryway. Through the den, there's a door and a small hallway, which also has a door into there's a small storage, rather, area here, plus the rear portion of the bar and a door into the dining room. This hallway also goes into the kitchen. Through the kitchen, there is a breakfast area, and the breakfast area, there's the service porch, which has a door to the exterior of the house. From the service porch is the maid's quarters, which also has a bathroom. How big is this first floor? Geez, it just keeps going on and on. Yikes. Okay. And then there's an exit door from the bathroom. There are also a set of French doors that leads to the outside from the den and another set of doors, French doors from the living room to the outside. And there's a small grass area outside these doors. And that small grass area is depicted on that larger interior exterior diagram which I showed you, which is marked as People's 2 for identification. Is that correct? That's correct. All right, now I'm going to ask you about, well, can you tell us, first of all, on this diagram where the actual crime scene was located? That is, where the bodies of the victims were found in this case. When I entered the residence, Jose was seated in this area here, which is the west portion of the sectional couch. Kitty Menendez was lying on the floor with her feet in a westerly direction. She was on her right side, I believe, and her head was toward the end of the coffee table in an easterly direction. Okay, now I'm going to show you an enlarged diagram of that den. But before I do, let me ask you this. Was there a second floor to this home as well? Yes, there was. Okay, I'm holding in my hand a large diagram of a second floor of that home. This was not previously used in the first trial. May this be marked as People's 6 for identification? The court says yes. Mr. Khan says Mr. Khan says, showing the People's 6 for identification at the time, if you would please, once again, identify the various rooms that you see on the floor of the home. From the foyer, the stairwell comes up, turns, and then goes to the second floor in this area, and he's pointing to that area. To the right is a linen closet. Through the hallway is a master bedroom, which has this depicts a door that's actually a window here and a window here. Through the master bedroom is the bathroom area, dressing area, and closet. This is indicated as her bath because Mrs. Menendez had this area here as her bathroom, dressing area, and closet. There's a shower in the front of the two sauna, and because Mr. Menendez had this, it's depicted as as his bathroom and his closet. Going the opposite direction through the hallway and a small, it was a, I'll call it a bridge, but an area that crossed over the foyer. And this bedroom number 4 was where Eric had his bedroom, his closet, his bathroom. And then there was a bedroom to the other side of the front of the residence that was empty. It didn't look like it housed anybody. A bedroom, a bath, a closet. Another bedroom was to the end of the hallway, depicted as bedroom number 2 with a dressing area, closet, bathroom. And another bathroom depicted as bedroom number 5 with a bathroom and closet on the northwest corner of the area. My God, how many bad bathrooms does this place have? Mr. Khan says, "All right, thank you. Now, directing your attention to the den itself, I would like to show you a photograph at this time, which was previously marked as People's 7 for identification in the first trial. May this once again be marked as People's 7 for identification?" The court says yes. Mr. Khan continues, directing your attention to that photograph, can you tell us what it is that you see is depicted in the photograph? That photograph is showing how the victims were when I entered the room on the morning of the 21st. It shows Jose seated at the end of the sectional couch. It shows the coffee table in front of him and Kitty to his feet and to his right side on the floor with her head facing away from him. Previously marked as 251 in the first trial as another photograph that was seen may be marked as People's 8 for identification. The court says yes. Ms. Abramson says, "Excuse me, Your Honor, was that 251?" 251, he confirms. Mrs. Abramson says, "Thank you, Your Honor." Mr. Khan continues, showing you 251. Can you tell us what you see depicted in that diagram? This is a photo where the photographer is taking the photo just inside the double doors, which is the entrance to that room, and the photographer is depicting the south side of the room with a table to the right of the photo, Jose Menendez seated again on the end of the couch, coffee table, and the French doors to the rear. Let me, at this time, show you some additional photographs which were not previously marked, which depict, Ms. Abramson says, "Excuse me, Your Honor, may I confer with counsel?" The court says, "Sure." So they talk a little bit, and then Mr. Khan continues. "These were not previously marked, and these depict the crime scene from different angles. I have a photograph which depicts an entryway to, appears to be the entryway to the den in the photograph. May these be marked as People's 9 for identification?" The court says yes. Showing you People's 9, can you tell us what this depicts? Yes, that's a photograph of the photographer standing in the entryway looking into the double doors into the den. With the den, you can see the sectional couch with Jose Menendez on the end of the couch and Kitty lying on the floor at his feet. Not previously marked as another photograph which appears to depict a view from the interior of the room to the entryway. May this be marked as People's 10 for identification? The court says yes. Would you tell us what that depicts? That's a photo from the photographer standing in the northeast corner of the den, looking in a westerly, southwesterly direction, depicting the double doors, the west wall, and a portion of the south wall, with Jose Menendez seated on the couch to the left of the photo. I'm showing you the same crime scene from another angle. I have a photograph which depicts the room taken from behind the sofa. May this be marked as People's 11 for identification? The court says yes. Can you tell us what this depicts in this photograph here? That's where the photographer is standing in the southeast corner of the den, looking in a westerly direction, seeing the west wall with double doors, the table in the corner, the couch in the foreground, with Jose Menendez seated on the corner in the corner of the couch. All right, I'll take those photos down and we'll show you some additional photos at this time. At this time, I would like to show you some closer views of the photos. I hold in my hand a photograph which appears to depict Kitty Menendez on the floor. May this be marked as Peoples 12 for identification? The court says yes. Previous number, asks Miss Abramson, and the court says, has that been used before? Mr. Khan says, yes, Your Honor, that was previously marked as Exhibit 96. The court says, all right. Can you tell us what that photograph depicts? It's a photo of Kitty Menendez lying on the floor in the front of the sectional couch with the coffee table to the front of her and Jose to her west side. Let me show you another photograph which appears to depict the legs of Kitty Menendez. This photograph was previously marked as 95 for identification. May this be marked as 13 at this time? The court says yes. Can you tell us what it is that is depicted in that photograph? It's a photo taken to the feet of Kitty, showing Kitty Menendez lying on the floor on her right-hand side is in front of the couch with Jose Menendez's legs and feet shown in the foreground of the picture. I would like to show you a close-up of one wound in particular. This photograph was previously marked as Exhibit 3993 for identification. May this be marked as Peoples 14 for identification? The court says yes. Showing you Peoples 14, can you tell us what it is that is depicted in that photograph? It's a photo of the lower portion of Jose Menendez seated on the couch, showing his hand, which are semi-crossed, and a wound to his left thigh just above the knee. Okay, let me ask you about the space and area the area surrounding the bodies at the crime scene. Can you tell us what it was that was directly in front of the bodies of the two victims in this case? Directly in front was the coffee table, which, when I got there, was a little bit of an angle, as if it had been pushed in front of Jose. Ms. Abramson says, I'm going to move to strike as assumption as if it had been pushed. The court says, sustained. That portion of the answer is stricken, referring to it having been moved. The jury is admonished to disregard that. Yes, directly across the room, in front of Mr. and Mrs. Menendez, was a big screen television. The doors were to the left, the entrance from the interior of the house of Mr. Menendez. There was a bar in the northeast corner of the room. There were bookcases on the east wall of the room and windows with French doors behind Mr. and Mrs. Menendez. Mr. Khan says, okay, I'll be showing a diagram of that room in just a moment. First, let me focus you on that coffee table. I have another photograph which was previously marked as Exhibit 250 in the first trial. May this be marked as Peoples 15 for identification? The court says yes. Mr. Khan continues, showing you that photograph, will you tell us what that depicts? That depicts the coffee table, as you stated, which was in front of Kitty and Jose Menendez. The right portion of the photo in the portion closest to the television, the left portion of the photo is the area closest to Mr. and Mrs. Menendez. Okay, and did you observe any food on the table? As depicted in the photo, there's a glass with a spoon in it, and it has residue of blueberries, I believe, and it was a white whipping cream. And then just next to that is a glass that had, I believe, lemonade in it. And did you observe any other dessert dishes or glasses such as that anywhere within the crime scene? Any additional glasses? Not within the immediate area of the crime scene. There was an additional glass and I believe a pitcher or at least another glass with the lemonade in the kitchen on the island counter. Plus, the additional glass had more berries and cream in it. So there were more glasses and things in bowls in the kitchen. I don't know why you would put berries and cream in a glass. So that's kind of bizarre that he said the additional glass had berries and cream, but maybe it was a bowl and he made a mistake in his words. And that was on the countertop in the kitchen? That's correct. Do you recall seeing any items on the floor near the coffee table? There were papers strewn about, as you can see in this photo, 15, I believe. There's envelopes with folders and newspapers. There were newspapers on a shelf below the coffee table, which were strewn about. And again, there was the envelopes that were strewn on the floor also, or papers from the envelopes at least. Okay. Depicting your attention to the photograph depicting Kitty Menendez on the floor, do you see some papers strewn on the floor next to her? Right. The photo on the right, or another photo, was does depict the envelope and paperwork that I described. Were you able to identify the nature of the paperwork that was there in that on the floor? Yes. What type was that? Ms. Abramson says, Your Honor, I'm going to object as hearsay. Overruled. So, yes, it was envelopes and correspondence from UCLA. Okay, at this time, I would like to mark a portion of a photograph which was apparently cut. This photograph was marked previously as 278 for identification at the first trial. May this be marked as People's 16? The court says yes. Showing you People's 16 at this time, would you tell us what it is that is depicted in that photograph there? That's the corner of the coffee table which depicts the correspondence that I described from UCLA. I believe that this one piece of paper says how to enroll on it. Mr. Levin says, I didn't hear that, I'm sorry. And Detective Zoeller says, yes, the one piece of paper that's depicted in that photo says how to enroll. So how to enroll in UCLA. Mr. Khan says, okay, now I would like the photograph that was marked as People 7 for identification, which depicted both Kitty and Jose Menendez. You're able to see the shuttered doors directly behind the sofa. Is that correct? That's correct. Now, were you able to observe any damage to those shutters and the glass of those doors? Yes. Would you describe for us what type of damage you observed there? On the door, if you're facing the door, it was double doors, French doors. If you're facing the door from inside, the door on the right had a hole in both the shutters themselves and in the glass on the doors. And the door on the left also had holes in the shutters and in glass. Okay, I would like to show you another photograph which was not previously marked and it appears to depict the exterior of those doors. May this be marked as People's 18 for identification. The court says 18. Ms. Abramson says, I'm sorry. The court says 17. 17. Okay, so they miscounted. Showing you what I've just marked as 17 for identification, can you tell us what is depicted in that photograph? That's a photo of the French doors from the exterior of the residence. And as I said, the right-hand door, which in this photo is the left-hand door, you can see the glass broken out in one of the panes. And on the right-hand side of the door, this photo, the left-hand door, as I described it prior, it shows the hole in the glass. Let me show you some of the close-ups of these photographs. I'm showing you what has previously been marked as 264 for identification. May this be marked as People's 18 for identification? The court says yes. Can you tell us what that photograph depicts? That photograph is a close-up photo of the hole in the door on the right-hand side looking at it from the outside. I have another photograph which was previously marked as 267 for identification. May this be marked as People's 19 for identification? The court says yes. Can you tell us what is depicted in that photograph there? That photograph shows from the exterior again a hole in the glass of the door on the left-hand side. I would like to show you what has been marked as previously marked as People's or Exhibit 38 for identification. May this be marked as People's 20? The court says yes. Can you tell us what is depicted in this photograph? That's a photo again from the interior of the house, and it shows holes breaking one of the louvers of the blinds, the the wooden blinds, and the hole behind it. Now, in that space behind the rear of the sofa and the louvered blinds, is there enough space there to walk? Yes. Your Honor, I have a photograph which was previously marked as People's or Exhibit 92 for identification. May it be marked as 21? Yes. Your Honor, I didn't hear the previous number. The court says 92. Thank you, Your Honor, says Ms. Abramson. And Mr. Khan continues. Can you tell us what is depicted in that photograph? It shows the area behind the couch to the double doors, the French doors. Okay. And do you see some material on the floor? Sorry, let me start that sentence over. Okay. And do you see some material on the floor that there in front of the doors? Yes. And can you tell us what that is? May I look closer? Yes. There's pieces of shutter, there's blood on the floor. It appears to be glass fragments. This is some body matter that I'm pointing to on the left of the photo by the doors and more splintered wood chips. All right, thank you. I have another photograph which was not previously marked and which appears to depict part of the same room. May it be marked as 22 for identification? The court says yes. Showing you what I have just marked as 22 for identification, can you tell me tell us what is depicted in the photograph here? It's a photograph depicting the northeast corner of the den, showing the east wall, which has a bookcase almost floor to ceiling, trophies on top of the case, a bar on the left-hand side, and the eastern portion of the sectional couch, what looks like a tennis racket on the couch and a tennis racket on the floor in front of the couch with the coffee table. Okay, now you've arrived at the scene. You've indicated that there was a television in the room. Is that correct? That's correct. Was the television on at the time? It was. And do you recall anything about the volume of this television? It was very loud when we entered the room. Would you describe the lighting that you observed at the time of your arrival? The only lights on in the den itself was the television. The light from the television, there was no other light. And the bodies, as they are depicted in all the photographs that I've seen so far, is that the way that they appeared to you at the time of your arrival? Yes. Was the furniture depicted the way it is now in all the photographs that I've shown you at the time of your arrival? Yes. And after entering the room, did you or someone else turn the lights on? I did not turn the lights on, no. Somebody did eventually, yes. And upon looking at the wounds to the victims, and in this case, did you have some idea as to what type of weapon might have been used to inflict those wounds? Yes, I did have an idea. And what was your opinion at that time? That a shotgun or shotguns were used? And what made you form that conclusion at the time? The size of the wounds. I observed wadding from a gun and the pellet holes in the door plus I might have, and I don't recall at the time whether I saw pellets at the crime scene or not. Now, tell us a little bit about the shotguns. Are you familiar with their operation? Yes. And what type of shot does, uh, hold on. And what type of a shot do shotguns shoot? So, weird question. Well, there's various shots that shotguns shoot, and there's various gauges of shotguns, gauge-wise, as small as a 410, 410, is that right? I would say 14 and up to 16. I have no idea. I don't know that seems like an error, which you don't see too often anymore. What does that mean, a 410 or a 16 gauge? It's the size of the barrel and or size of the rounds that the shot is in, the size of the rounds that is shot in that weapon. These people are horrible at grammar, which makes these sentences horrible to read. It's hard to read people's, uh, like when people are talking, it's hard to read because people don't always speak in perfect grammar and or in perfect ideas. Like they cut themselves off like I just did and go and talk about, something else. So whatever. It's just, it is what it is. We will make do. When you say size of the barrel, are you referring to the diameter of the barrel? Yes, 410 is smaller and it goes up to the larger size, with the larger size being a 16 gauge. And tell us a little more about the shot or what comes out of the shotgun. The shot has various loads. They call it loads in a shotgun, has various loads. It goes anywhere from a small BB, very small pellet, to just one projectile, which is called a rifle slug, and it has varying sizes in between. And you indicated that at the time that you arrived at the crime scene, you observed, let's take for example, the area of the shutters. Do you see separate pallet defects in those shutters? That's correct. Now, when a shotgun is fired, can separate pellet defects. Okay. So each little pellet made a different damage, made different damage to the shutters. Says now, when a shotgun is fired, can you tell us what happened to the shotgun shells that contained the pellets? Depending again on the shotgun that is used, there's some shotguns that just have one or two shotgun shells that fit into it and they have to be physically taken out to reload. Then there's other guns that have a tube that holds a certain designated number of rounds. And then after it's shot, you either eject the rounds out, which will expend the rounds out of the port on the right-hand side of the weapon, or on automatic ones, the shot does the ejection automatically, which again ejects the round out to the right. That couldn't have been more confusing. I understood the premise, but this is very confusing. So now those types of shotguns that hold either one or two shots, do you have to physically remove the shotgun shell, the expended shotgun shell from the shotgun after it has been fired? Yes. And for another type of shotgun that holds multiple rounds, the kind that you have to pump to eject in a new shell, are those shells ejected from the shotgun? If first of all, is this guy a shotgun expert? Why is he testifying to the mechanisms of shotguns? I really don't think that he's an expert for this, and this should be out of his scope of expertise, but I would have objected. And for another type of shotgun that holds multiple rounds, the kind that you have to pump to eject in a new shell, are those shells ejected from the shotgun? By the pumping action, when you pull it back to put a new round into the chamber, it actually ejects the old round out of the ejection port. As part of your investigation of this crime scene, since you made a determination that shotgun shells were apparently fired inside that room, did you conduct a search for shotgun shells? Yes. And did you find any shells? I found none. Did you find any items of evidence which you recovered from the crime scene? Yes. What items of evidence did you recover? In reference to the weapon or what weapon was used, I recovered wadding, spacers for shotgun shells, and some shotgun pellets. Now, when you say pellets, you're referring to those round metal BBs or metal balls they shoot from the shotgun. I take it? That's correct. What do you mean by spacers? Within a shotgun shell, at the base of a shotgun shell is a primer. Above the primer is the gunpowder. And the manufacturer generally puts a spacer there, depending on how much load they have loading the ammunition. And they have a cup that goes around the ammunition that holds the ammunition in place, and the end of the shotgun shell is crimped to keep all that inside. What? Let me pull up a picture here. Hold on one second. All right. This is for people who need to see a visual. So you've got, as you can see, the primer here. That's what I believe that's off the gunpowder. There's the wadding in between the gunpowder and uh, the pellets. So these are the little BBs that are inside all of the shotgun shells. So this one, they're larger, so this would be more like a buckshot. In a bird shot, you'd have many more but smaller pellets. And remember, they used both in this case because when they purchased the shotgun shell, or when they purchased the shotguns, they had loaded them at that store with birdshot. But then when they went to go try to go shoot them at a range and ask questions from, well, they found out that they couldn't use shotguns on the range. But then the people that they were talking to at this other place where they tried to use the shotguns at the range told them you have the wrong stuff for protection. You should use buckshot, which is these bigger pellets. They had birdshot from originally the original store, so that's just a little story on that. So you can see the wadding. I don't know what it is, if it's like a plastic or a fabric. I picture it like fabric, but I have no idea what it is made out of. I want to know. Anyways, back to it. So a spacer is something that is placed between the gunpowder inside the shotgun shell and the load or the pellets. Is that correct? That's correct. And what are spacers made out of? Generally, some type of paper or fiber material. And I think recently they've gone into plastic. Okay, so all kinds of different ones that they make. And you also said that you recovered wadding. Can you tell us what wadding is? Wadding is that fiber material or the spacer. Where'd my picture go? Did I close it? Oh, I closed out of it. Never mind. I was gonna open it for you again. I don't have it. Here you go. So again, it's that piece in the middle, separating gunpowder from pellets. Whoops. Ah, too many windows open. All right, so is wadding is that fiber material or the spacer. So is wadding and spacers the same thing? Yes. Now, before you removed items of evidence, such as wadding or pellets, did you photograph the position that these items were observed in? I had the items photographed, yes. Your Honor, I have another photograph which was previously marked as 21 for identification. May that now be marked as 23? Yes, the court says. Okay, directing your attention to the photograph that I have just put on the board, People's 23, can you tell us what is depicted in that photograph? It's a photograph of from outside of the den into the den, and it depicts the numbering system of the position of evidence in that room that was collected, photographed, and collected. Okay, are you referring to what appears to be on the floor? Little numbers on which appear on little square yellow markers? Yes. What do those numbers correspond to? So those you've all seen those little it's not really a square. It's more like a tent card, the evidence markers that they put out on little yellow like let me see. You guys know what I'm talking about. There, you've all seen like those evidence markers, like these guys here. You can buy your own and do your own evidence marking all over your home if you want. There you go. Walmart has them. What? Seriously? 10-piece? Oh, it's a restaurant. Wait, restaurant evidence markers, double-sided number markers, acrylic table signs. Uh, oh, they're for decorations or something. If you have a true crime wedding, oh my God, that would be amazing. A true crime wedding, theme wedding. Okay. Anyways, so yes, those yellow markers. What do those numbers correspond to? They correspond to the collection of evidence. The number one will correspond to the first item of evidence that we took that is listed on our evidence register, which is a record of the evidence that we collected. Okay, let me, at this time, I'd like to mark for identification an exhibit which was not previously used before, which depicts the den. May this item be marked as court, says 24. He says the People's 24. Directing your attention to People's 24 for identification, can you tell us what that depicts? It's a diagram depicting the location of each of the items collected, each of the items of evidence collected of the morning of the 21st of August of 1989. For those of you who are also paying attention to the Karen Reed case, there was not one of these of the crime scene of John O'Keefe. And we're supposed to take the word of police reports when everyone has said, well, that's not what I said in a police report, as to where things were located and what happened. There were things were not measured out, things were not um, depicted in diagram form, and that is something that is seriously lacking in the John O'Keefe investigation. Okay. And with your assistance, what I will do at this time is I will point out particular locations on that diagram, and I would like you to identify, if you would, what that is depicted in each of the locations that I'm pointing, okay? Okay. Ms. Abramson says, excuse me, before council does that, could we ask that the other charts be moved so we can see without having to get up? The court says, sure. Thank you. Mr. Khan? Yes, if I may refer to the report that was made, that was prepared, so I can, although it does have a legend on the side. Stevenson says, could I approach the witness, Your Honor, just to see which report he's holding? The court says, sure. Yes. Mr. Khan says, all right. Directing your attention first to item number 1, which appears to be near the entryway to the room. Can you tell us what is depicted there? It was a hair sample that was collected. Directing your attention now, and by the way, are these numbers that appear on the board color coded in accordance with a legend that appears in the upper right hand side? Yes. And will you explain to the jury what that color code consists of? Well, as you can see, the wadding is depicted by the red and the pellets are depicted by the orange. And everything else which is labeled is depicted by the yellow circles. All right. Directing your attention then to your report, if you need your report to refresh your recollection, I'd, I would like for you to describe to the jury at the time the various items that were recovered from that room. Items number 2, can you tell us what this depicts? That's the shotgun wadding. And also, when we collected it, we measured within the room the exact location where it was recovered. Although we have it memorialized by photographs, we actually have measurements. Item number, the middle of the room, 3. There was no question. I don't know where that came from. Can you tell us what that depicts? Number 3. Number 3 is a shotgun pellet that was recovered. Item number 4 is another shotgun pellet. At the body, you mean of this, near the right-hand side of Jose Menendez, there appears to be 2 number 5s. Can you tell us what that means? The one number 5 is a shotgun wad, which was on the couch. The second one is a piece of white, which appeared to be a white plastic bracelet, a piece of it, a broken piece of it. Why would they have the same evidence number? That makes no sense. In the cushion adjacent to where Jose Menendez was found sitting there's the number 6. What does that relate to? A shotgun pellet was located there. Item number 7 is on the middle section of the couch. Can you tell us what that refers to? It's a piece of white cloth. Item number 8 is over on the far end of the sectional couch. Can you tell us what that refers to? It was a shotgun pellet on the couch. Item number 4 is located right next to item number 8. What does that refer to? It was a cordless telephone, and when I arrived at the location, it was actually under a throw pillow on the couch. Okay, can you tell us why, for example, items such as a telephone would have been marked as an item for identification? Because it was taken as evidence. We took it to process it for fingerprints. I see. Wh- Fingerprints? Who cares? What would that prove? Well, I guess okay, if I don't know, but it was hidden. I don't know. Okay. I guess if you don't know who did it and fingerprints is the way to go. I was thinking for a second like they knew it was Eric and Lyle. They didn't know that at the beginning. All right. Because it was taken as evidence, we took it to process it for fingerprints. I see. Something like that, for example, the hair you said you was marked as an item 1 for identification in your property report. Can you tell us why that was taken and marked in your property report? As evidence to see whether eventually we could match it to a suspect or eliminate it through the victims or other known people. All right, number 10, can you tell us what was found there? A shotgun pellet. Mr. Levin says, Mr. Levin, upper left. Item number 11 will tell you what is depicted there. I don't know why Mr. Levin interjected there. She might have meant Khan. Um, okay, so number 11 was a shotgun wad. Item number 12 was a shotgun wad, and it was found on Mr. Menendez's right thigh area. Okay, item number 13. A shotgun wad found under Mr. Menendez's right hand. So he was standing. He wasn't sitting in that position when they entered the room. There were things under him. There were gunshots, there were wounds that were like on the back of his elbow, which wouldn't have made any sense because his elbow was on the back of the couch. So he would have had to have been shot through the couch if he was sitting. And that makes and he wasn't. The couch wasn't shot that way. So it his gunshot they because the state tries to say, well, they were just sitting there, just minding their own business. But in actuality, the brothers both testified that they were standing in the room at the time. So they were probably standing there talking, going, well, what the hell are we going to do? Because we don't want the secret to come out. So who knows what they were plotting or planning at the time, and who knows what punishments may have been coming, whether it would have ended in the brothers' demise or not, they still were in bodily harm. They were in harm's way. So, all right. So 13 was a shotgun found under his hand. Item number 14 is a shotgun wad that was on the floor. Item number 15 is a shotgun wad that was found in front of the couch. 16 is another item of the white plastic bracelet. Okay, item number 17 is a shotgun wad on the floor. Item number 18, another shotgun wad. Why are we doing this one? Like, he could have just had him go instead of question number 19. It's a shotgun wad found on some cushions that were there, some green cushions. I think they were outside chaise lounge type cushions. Item number 20 was a shotgun wad. Item number 21 appears to consist of 3 items. Can you tell us what that consisted of? The 121 is a shotgun wad. The one in blue is a piece of the white plastic, another piece of the white plastic bracelet, and C is a pellet, a shotgun pellet. Item number 22 in the far right hand corner, what does that consist of? Is a shotgun wad. Item number 23 at the top of the diagram, what is that? That was a footprint stain that was located on the floor outside the den itself. I believe it was right on the inside of the kitchen floor. They had a footprint and they still didn't put two and two together and think, oh, let's ask the brothers. Let's look at their shoes. Didn't even think about it, I guess. That's great policing. All right, Ms. Khan says, Ms. It's a Mr. Mr. Khan says, okay. At this time, I would like to mark some additional photographs. At this time, I would like to mark for identification an exhibit that was previously marked as 22. May this be marked as 25 for identification? The court says yes. Showing you 25 for identification, can you tell us what is depicted in that photograph? 25 is the hair sample that we found on the floor, which is depicted as evidence item number 1. Previously marked as 23 for identification, I would like to mark this photograph as 26 for identification. Can you tell us what is depicted in that photograph? It's item number 2, the second piece of evidence that we took, and you can see the wadding right below the stanchion in the photo. Ms. Abramson says, excuse me, Your Honor, may we approach? The court says yes. Then, continuing on, Mr. Khan says, previously marked as 24 for identification, I would like to mark this photograph as 27 for identification. Can you tell us what is depicted in this photograph? It's evidence item number 3, and it depicts a pellet, and I believe the pellet is right in front, again, of the stanchion, this small dark item. I have a photograph which is now previously marked, which depicts a portion of a sofa. May this be marked as People's 28 for identification. The court says 28. Ms. Abramson says, could I confer with counsel? They speak again. All right. Continuing on, Mr. Khan says, I'm showing you People's 28 for identification. Can you tell us what is depicted in this photograph? It's evidence item number 4, and the piece of evidence is the shotgun pellet, which is, again, right below the stanchion itself. I have another photograph which was not previously marked. This photograph depicts the right-hand side of Jose Menendez. May this be marked as People's 29 for identification? Yes, the court says. Abramson says, Your Honor, I'd like to approach on this. This is the first I've been shown People's intended to use this photo. Okay, the court says, we'll move on. It will be marked at 29 at this point. Go. So he didn't want to see Leslie on that. He was just like, nah, I don't care about your complaint. Let's just move on. So go on to the next exhibit. Oh, go on to the next exhibit. Mr. Khan says, I have another photograph which I would like to mark as People's 30 for identification, which appears to depict an item. So he marked it at that point, but they didn't let him ask any questions. So he's probably like, we'll come back to that. We'll mark it for now, I guess. I don't know. Which appears to depict an item that is stage or tagged number 6. May this be marked as People's 30 for identification. Mr. Levine says, was that 30? The court says Exhibit 30. Showing you People's 30 for identification, can you tell us what is depicted in this photograph? It's an evidence item number 6, and it shows a pellet, shotgun pellet, just below the stanchion again. So the stanchion is the yellow evidence tag that he's talking about. So it's just below the stanchion. Mr. Khan, I hold in my hand a photograph that was previously marked as People's 25. May this now be marked as People's 31 for identification? The court says yes. Showing you 31, can you tell us what this depicts? It's the evidence from number 7 showing a white piece of cloth to the left of the number 7 stanchion. I hold in my hand a photograph which was previously marked as 26. May this photograph now be marked as People's 32. Showing you 32, can you tell what is depicted in this photograph? There actually are 2 stanchions or 2 pieces of evidence. Number 8 to the left of number 8 is a small pellet or a pellet that you can see And number 9, which shows a throw pillow on the couch, and you can see the antenna sticking out from beneath the pillow. Showing you a photograph previously marked as 27 for identification, I will now mark as 33. Can you tell us this time what this photograph depicts? It's evidence item number 10, and right below the stanchion itself is a shotgun pellet. I have a photograph in my hand previously marked as 28. I will now mark as 34 for identification. Can you tell us what this photograph depicts? It's item number 11 of evidence showing wadding. I have another photograph which has not been previously marked. This photograph depicts number 12 in the photograph. May that be marked as People's 35 for identification. The court says 35. Showing you what I have marked as 35 for identification, can you tell us what that depicts? It depicts evidence item number 12, which is just below the stanchion itself on Jose Menendez's thigh. You can see a wadding in the edge of the pant leg. I have another photograph which was not previously marked. That photograph depicts the number 13. May this be marked as number 36. The court says 36. Ms. Abramson says, Your Honor, we need to discuss this. The court says, okay. Mr. Khan says, I have in my hand a photograph previously marked as 29 for identification. Will mark as 37. Can you tell us what this photograph depicts? It's a photograph of items number 14 and 15. 14 is a shotgun wad, which it appears is just to the left of the stanchion, and number 15 is also a shotgun wad, which I can't determine from the photograph exactly where it is in the photo. I have photograph in my hand previously marked as 35 for identification. I will now mark this 38 for identification. Showing you 38, can you tell us what this depicts? Evidence item number 16, showing the piece of white plastic which we labeled as bracelet. I have in my hand a photograph previously marked as 31 for identification. I will now mark that as 37. Abrahamson says 39. He says, sorry, 39. Can you tell us what that depicts? It's evidence item number 17 with a wadding to the side of the stanchion. In my hand is a photograph previously marked as 32 for identification. I will now mark as 40 for identification. Can you tell us what that depicts? Evidence item number 18 with a wadding next to it. I hold in my hand photograph previously marked 35 or 33 for identification. May it be marked as 41. Can you tell us what this depicts? Evidence item 19 with a wadding again next to it. This is all very repetitive, so sorry about that. You guys wanted all of his testimony, so I'm going to read all of it and you'll hear what the jury hears. In my hand is a photograph previously marked as 34 for identification. I will now mark as 42. Can you tell us what that depicts? Evidence number 20, which again is the wadding next to the stanchion. In my hand is a photograph previously marked as 35. I will now mark this for 43 for identification. Can you tell us what that depicts? It's evidence item number 21, and it shows a wadding to the left. I'm sorry, in the picture to the left of the stanchion, and then to the left of that you can see a shotgun pellet and a piece of the white plastic bracelet. I have in my hand a photograph previously marked as 36 for identification. I will now mark that as 44 for identification. Can you tell us what that depicts? Evidence number 22, the shotgun wad in front of the number. Thank you. Your Honor, this might be a good time. The court says, all right, let's take our recess and we'll discuss these other photographs with counsel. We'll resume at 1:30. Don't discuss the matter with anyone and don't form any final opinions about it. And we'd ask you to return at 1:30. The jury exits. Now the court asks counsel, you wanted to discuss something. Ms. Abramson says, I wanted to discuss a number of things, Your Honor, but not not the least of which is that Mr. Khan obviously didn't show us any of those photographs that he wanted to mark for identification. It's the first time before, even though I walked over there and asked Ms. Nahara if there were going to be new ones. I don't like to, it just seems, I don't understand why they never listen when you tell them to show us things. The two photographs, if I could have them again, since I didn't have time to pull mine. The court says 29 and 36. Ms. Abramson says, okay. First of all, 29, it's virtually impossible to see the piece of evidence in the photograph, but what you do see is an especially gory view of Mr. Menendez. It shows both the wounds of the back of the head. It shows pools and pools of blood, and you really can barely see the piece of evidence. So really, this is just to incite some kind of emotion, I think. And that's what she's getting at. So if they want to, in fact, they could let me just show the court. You can see 29 in my hand. The piece of evidence, I believe that one was 8. If they want to crop it and just show the piece of evidence, if that's the purpose of the photo, fine. But to show the bloody, gory view, which doesn't illuminate anything with respect to the reason these are coming in, we object to that. And 13, again, as a close-up of a bloody section, you can't even see them or see the item. You can see the card, but you can't see the item. So that the court says that's 36. Ms. Amerson says, yeah, 36, that Your Honor, yes. And let me hand them up to the court so you can see them up close. The court says, all right, as to whether or not you can actually see the items depicted in these photographs, Mr. Khan, yes, we are offering the photographs simply to depict the location where each of the items were recovered from, and I think that which it may be is that the item is somewhere near that stanchion or to the side of that stanchion. So I would submit that the photograph depicts the location where each item was recovered from. The court says, I have no problem with that. The only question is whether or not there is some other photograph that would serve the same purpose. You have other photographs of the of the scene showing the locations depicted here. Item number 13, items 4 and 5. I'll ask that you review your photographs and see if there are some others that show the same location. Above and beyond that, let me just say again, both sides are expected to show photographs to the opposition the day before. Obviously, today is today, and you can't show photographs yesterday. But before you show any photographs, use any exhibits, you are to show them to the opposition so that they can state any objections to them. Ms. Abramson says, yes, we've just been handed another photograph. Wow. If I were her, I'd be fuming, and the court, I mean, he's addressing it, but not really. He's not being really firm with the prosecution. He should say, it's not coming in because you didn't show it to them ahead of time, so it's not coming in. Did he not just say that in his earlier tirade about you need to show 24 hours and blah, blah, blah? The court says, I'll let you look at them. I'm not going to deal with this at this point. We'll resume at 1:30. Ms. Abramson says we still have some other matters we'd like to call to the court's attention. The court says, what's that? Ms. Abramson says, perhaps we should approach for this, Your Honor, if we could. The court says, all right, we'll just take a recess here and clear the courtroom. She says, thank you. That means we'll clear the room. And the bailiff, everybody has to leave. Mr. Berg says, I'm from the Daily Journal and I'd like to respectfully ask for a brief delay so we could contact a lawyer to come down on the issue of closing the courtroom. So some guy from the Daily Journal is like, no, I object to you closing the courtroom. The court says, well, routinely during the course of the trial, when matters have to be discussed with the court, if there's an issue of confidentiality or right of privacy or issues that might be potentially prejudicial, the court will discuss matters in camera with counsel. And if I determine that these are issues that could have and should have been discussed in public, then those transcripts will be made available. Everything will be done on the record. The reporter says, Your Honor, may I get his name again? State your name. The reporter says, Your Honor, yeah, may I get his name again? And the state says, or no, he says, state your name again. He says, Mr. Berg, Martin Berg from the Daily Journal. Thank you. The witness says, my name is Jeff Michaels of KABC News. If any items being discussed have to do with the press, no, then I'd ask that we be allowed back in. Following proceedings were held outside the presence of the public. So he's like, no, all you news people get out of here. Court says, all right. Ms. Abramson says, there are actually three things to discuss. One of them didn't really need the courtroom to clear. The court says, then don't talk about it. Abramson says, we can talk about it when we come back. It has to do with the witness list we were handed this morning, which was entirely different. Ms. Towery says, not this morning. Ms. Abramson says, not until we demanded it. The other thing, so they had to demand the witness list, and it's wrong, or it's already had some discrepancies with it, something. The other thing that has to do with observations that were made in the courtroom and relayed to Mr. Gessler and myself during the morning recess by an attorney named Carrie M. Pines. She was here when I wanted to bring the matters up earlier, but she couldn't stay until noon. She made out a declaration under penalty of perjury while she sat in the courtroom, which indicates that she was in the courtroom this morning and during opening statements of defense counsel. I observe she, quote, I observed procedures which concerned me and that I called to the attention of defense counsel during the morning recess, end quote. What she cites in this declaration is during opening statement, she saw one of the jurors that appeared to be drifting in and out of sleep. And the other thing, which I'm more concerned about, from where I was seated, I could barely see the female member of the prosecution team during defense counsel's opening statements. This prosecutor was grimacing and making inappropriate and unprofessional facial gestures directly at members of the jury. Holy cow. That is complete but blatant misconduct. It was clear to me that her behavior was directly correlated to the remarks of the defense counsel. Quote, at the morning recess, I called these facts to the attention of defense counsel merely because it appeared to me that these actions by prosecutor were unobservable by both the defense and the court. I declare under penalty of perjury that the foregoing facts are true and correct and within my personal knowledge. End quote. And it was signed by Attorney Pine. So it's coming from another attorney, which makes it even more credible. It's not just some Joe Schmo from the public saying, yeah, I saw some things that kind of freaked me out, but no, I'm an attorney and I saw this and this is wrong. And that's why I'm bringing it to your attention. Now, Your Honor, the prosecutors, have turned in such a way during argument as they were during jury selection, so all we see is the back of their heads. I haven't been paying any attention to what they've been doing. This is a person I've never seen or met before. She used to work for the district attorney's office, she told us, as a clerk, and they merely approached us in the hallway and gave us this declaration. I just don't want to have to post guards in the courtroom because the prosecutors are so close to the jury and can be so easily heard or observed. But this kind of behavior went on, to our knowledge, only after we spoke to the jurors in the first trial as well. So they were doing it in the first trial too, in these tiny courtrooms where the prosecutors sit next to the jurors. The court says, I am not concerned about the first trial. Ms. Abramson says, I'm concerned about this one, and I'm concerned about the notion that we have to police our colleagues who certainly should be professional enough not to do that. We can barely even see the jurors. There's so many bodies lined up at the table, and given the configuration of the room, they're in a position where they can make eye contact or do whatever they want all the time. They're under a greater burden, even because they can be observed, I would think, to behave. Ms. Towery says, I have something to add to that, to what Ms. Abramson said, and I didn't intend to bring this to the attention of the court. As a matter of fact, I brought it to the attention of Ms. Nahara this morning before court commenced. That is that yesterday when Ms. Abramson was giving her opening statement, a young gentleman from the district attorney's office who was sitting in a direct line of sight of one of the jurors, who he happens to apparently know, he's the law clerk or deputy district attorneys with red hair who's been assisting the district attorney in this case. He apparently is the young man who the juror, who's a law student, knows or has seen during school. And I watched him during Ms. Abramson's opening statement, and he laughed, tittered, made faces, grimaced, and whispered to his colleagues throughout at first, or at least the first hour of her opening statement. So he was doing it for an entire first hour. I then checked the seat in which that juror was sitting to see if that behavior would have been visible. The court says, "Let me just stop you for a second. Are the jurors still in the jury room?" The bailiff says, "Yes." "Are they ready to go?" The bailiff says, "Yes." "Let them go out first." A brief pause while jurors exit. The court says, "All right, go ahead." As I indicated, Ms. Towery says, "As I indicated, I didn't intend to bring this to the attention of the court. I did check to see if the juror could see this young man's facial gestures, and it appeared that he could very easily. I did not see him look in that direction during that time that it was going on, so hopefully he did not observe it. He seemed to be watching Mrs. Abramson and not further over to the right of her. However, rather than bring that to the court's attention, I told Miss Nahara this morning before court commenced, and obviously, given the more recent complaints regarding her own facial expressions, perhaps the court ought to have that information as well. The court says, "Okay, Ms. Nahara." She says, "Thank you, Your Honor. Two things. First of all, with regards to this is a sealed hearing, isn't it?" He says, "No." "Well, I'm going to say this anyway. With regards to Mr. Gessler's opening statement, and meaning no disrespect to Mr. Gessler, but quite frankly, it was so unriveting that I tuned out most of it." Oh my God, what a bitch. Wow. 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 Like, I'm speechless. You're not supposed to say that. Even if you think it, you're not supposed to say it about your colleague who just presented an opening statement. It was so unriveting that I tuned out. You were supposed to be paying attention because you're putting on a case that you're supposed to, you know, refute the defense's strategy because you can't have reasonable doubt, right? So, anyways, moving on. I'm speechless. I don't know what to even say about that quote. So, or about what you just said. Who is this Ms. Nahara? I don't know if it's Najera or Nahara. I imagine it's maybe like a Latino name and the J is an H sounding. I don't know. So I really don't know how this personage could think I was responding to things. Quite frankly, I had trouble getting up or staying awake through it. I'm sorry, Mr. Gessler, but that is the truth. What a effing see you next Tuesday, for those of you who don't like that word. I don't want to say that on my channel anyways, but I do say it in real life, and I don't mind that word. I call a lot of people that. Because sometimes they just are. All right, so secondly, I think the whole reason this whole situation suddenly came to a head is because Ms. Abramson was very much aware that I was about to get up and bring some points to the court's attention, which it is that when Ms. Abramson was up there standing by the witness looking at the jurors, everyone in the front row commented to me, and I noticed I even cleared my throat because she knew I was watching her so she would see me and stop doing it. Basically, she put on a performance over there, Your Honor, rivaling something out of Masterpiece Theater. That woman commented on every item of evidence that Mr. Khan sent up there. Every time he gave Detective Zoeller a picture, she rolled her eyes. She said this is at least three times, and she did this at least three times, and she knows I know she did it, and I caught it, and we made eye contact. She came down here and made an audible, unreportable sound 3 times. I assume this was to show her displeasure at not having been shown these photos. If she has displeasure about that, she has no business commenting about it in front of the jury, but she did that. And she knew I caught her doing that because she saw the notes coming from behind me saying, "Why is that woman rolling her eyes and commenting on every piece of evidence?" She knew that I commented on to Mr. Khan when she was up there, and I thought perhaps we should stop the proceedings and bring that to the court's attention. Mr. Khan wanted to go through with this because examination of Detective Zoeller, he had momentum going and he didn't want to break it up. I had asked the court about this previously, and the court said that when I saw this sort of behavior, I should bring it up to the court when it happened. Sometimes we don't want to break up the momentum of the witness you have on the stand and you don't call it to the court's attention. But everyone in the courtroom saw her putting her little performance up there, and she knows I was going to bring this to the court's attention, and I suspect that's where all of this Bol Folderol comes from? Balder whatever that word is, I have no idea. In any event, this has been going on throughout the whole trial. That woman was up there rolling her eyes up there, audibly gasping, basically putting on a performance, commenting on every piece of evidence. I think that's highly inappropriate. She should have been up there stone faced watching what was going on. She didn't. She knows what she was doing and continues to do it, and I suspect that's what this is all about. Mr. Gessler says, "May I respond for a moment?" Ms. Abramson says, "Don't even answer it, Charlie." Mr. Gessler says, "Number one, I was up there with Ms. Abramson, and I observed none of this happening. Number two, this is a response to something that is supposed to have happened between 11:30 and 12 this morning, as Ms. Abramson reported. Our encounter with this former law clerk from the direct attorney's office happened at the recess before either of us were up there looking at pictures. And she told me what is in her declaration, which had occurred between 9:15 and 10:19 this morning. So your timing's off for whatever she's insinuating here about Ms. Abramson. So this is not some kind of preemptive strike to the court because someone thought Ms. Nahara was going to bring some attention to the court concerning Ms. Abramson. This is something that happened before that. The court says, all right, let me say this. I don't know what was observed by Ms. Pines. I don't know what motivates her to contact counsel rather than contacting the court. The court was here. The court staff was here. What I'm going to say is that number one, I did watch the jury, and there is one juror who tends to keep her eyes closed during portions of the opening statements. She did that yesterday and did this morning. Oftentimes, it appears to me that she's just looking down, not closing her eyes entirely, and I didn't observe anybody on the jury nodding off. That's number one. Number two, as far as the observations of Ms. Nahara, I did not see any of the things complained of. Obviously, if they occurred, they'd be entirely improper. I've said this before. Ms. Nahara has a tendency to make faces, and if she does, while the jury is in the box, the court will take appropriate action. As far as counsel at the witness stand in dealing with exhibit, hold on. He knows Ms. Nahara has a tendency to make faces. So it's very likely that the faces she was making during Leslie's opening statements were probably true. As far as counsel at the witness stand in dealing with exhibits, these were small exhibits that required counsel to observe them as they were being displayed so that they can be aware of the exhibits. I do not hear any remarks made by either counsel. If they were made rather quietly. There was also some discussion between defense counsel and the prosecutor at the podium, which could have been heard by the jury. I only heard whispers. I did not see any behavior on the part of Ms. Abramson as described. I did not see any behavior on the part of Ms. Nahara as described by Ms. Pines. Either such behavior, whether by Ms. Nahara or by Ms. Abramson, if it did occur, is entirely improper and unprofessional. This is the way to handle it. So he didn't see it, but he's not saying that he doesn't believe anybody, but he's just saying going forward, this shouldn't happen. It's if it did happen, it's improper. And to use the more appropriate description, childish, extremely so. And if it occurs, the court will deal with it by bringing it to counsel's attention and directing counsel not to repeat any such behavior. The court will say that now that no counsel is to behave in will say it now. No counsel is to behave in such professional childish behavior, and if it does occur, then the court will deal with it, and the court is empowered and expected to. The court should be tried as a trial where everyone acts as professionals. If you can't do that, then there will be certain constraints upon you, which will reinforce your obligations to act as professionals. That applies to both sides. So that's a pretty stern warning there. If you want to spend your time dealing with these issues and the consequence of violating the court's directions, then you're inviting someone or something that you should think twice about. Ms. Nahara says, Your Honor, may I say something? No, no. She says, Well, and the court says, We've discussed it here. That's it. If anybody misbehaves, you see it occurring, you feel it's of such significance that you feel that we could occupy the court time and you feel it's prejudicial, you let me know when it happens and I'll deal with it. But I haven't seen any such thing here. So I can't really respond to it. Ms. Nahara says he says, if it does occur, then as I said, I'm going to deal with it either side. If you want to sink to such low levels that you would believe in such a fashion, just be aware of what's going to happen to you if you behave. Sorry, I said believe. If you believe in such, or if I just did it again. If you behave in such a fashion, just be aware of what's going to happen to you. Ms. Nahara says, I take umbrage with the court saying that they had noted that Ms. Nahara makes faces, like somehow this has been said before. Ms. Abramson accuses me of this. The court had never accused me of this. The court says, okay, well, I had that thought, and I didn't say that, and I didn't say it, Ms. Nahara, but you clearly do make faces. She's trying to fight back, and he's like, nah, you really do make faces. She's like, the court is saying that I do, and Ms. Abramson doesn't. I'm not saying anything about Ms. Abramson. I'm saying you do. Ms. Nahara says, the court has singled me out for this. The court says, that was the only thing I referred to here. Yes, you believe, but believe me, I'm aware of the peccadillos of all counsel. The peccadillos? What? Of all counsel and the types of behavior and misbehaviors that all counsel engage in, and I'm aware and will be aware of it and deal with it, whether it's you or anyone else. Ms. Nahara says, but the court has signaled me out. The court says, listen, I've said what I've said. Believe me, I'm aware of all the rest, and I am not going to ignore what else might occur. We're in recess. Ms. Abramson says, Your Honor, this afternoon, he says, we're in recess. Ms. Abramson continues, we're going to be asking the court for a gag order in this case after lunch. The court says if either side is asking for a gag order, as you just indicated, you might as well do it in open court. Ms. Abramson says, Thank you, Your Honor. Ms. Towery says, could we address the court after lunch before the jury comes in about another matter? The court says yes. Proceedings were adjourned, and this is a good spot to end. And we will come back with the state's case. I guess we'll begin the state's case part one, continued, and go from there. So we'll continue on. And thank you guys so much for joining me and reading along with me. Don't forget, you can find the links to all the documents below. And I will see you guys in the next one. Please don't forget to hit the like button also on your way out. Thank you so much for joining me. Take care, guys. Bye now.